All rise. Justices of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division. So, in your attendance, it shall be heard.
Thank you. Good afternoon, everybody, and welcome to the Appellate Division, First Department. Nice to see you all here today. We have about 5.5 hours of argument that has been requested, so we will have to ask you to reduce the amount of time that you ask for. Remember, we have had the briefs and the records for some time and are quite familiar with your cases. Just hope that you'll emphasize the important points and then be here to answer our questions. When the white light goes on, that means you have 2 more minutes. When the red light goes on, that means you should finish up your statement. If we still have questions, we will continue to ask you questions. When I call out each case, if both parties or all parties would rise, and you'll let me know how much time you would like. So the first case to be argued on the calendar today is People versus Jones. Oh, yes. You the appellant?
I'm here for respondent.
Where's the appellant?
I don't know. Submission is fine.
Submission, okay. Thank you very much, counsel. Gonzalez versus Daily Housing. Appellant? How much time would you like, counsel? 5 and 2, okay. And respondent? Okay, great. 5, 2, and 5. Thank you. H. Nathaniel? Anyone here? Submitted. JG and Infant versus St. Luke's Hospital. And respond. Okay, I'll give you 6 and 2 and 5, and we need some more, we'll give it to you then. Martinez versus Ravi. I believe I have 2 appellants on that case. Ravi. Okay, and the co-defendant? And what about respondent? 3, 2, 3, 2, and 4. Okay, thank you. Golden Nugget versus Chan. Respondent? Okay, we're going to do 6 and 2 and 6. Thank you. People versus Rivera. Respondent? I will give you 8, 2, and 8 on this case. Thank you. Arch Specialty versus Nautilus Insurance. Arch, you are the appellant? Okay, and Nautilus, you have a cross appeal? Okay, fine. 5 and 2 for each of you. Thank you. Sayreville Seaport versus Indian Harbor. Respondent? Okay, I'm going to give you 6 and 2 and 6. If we need more, we'll go accordingly. Harris versus Bronx County DA is submitted. People versus Guillory. I'm going to do 5 and 2 and 5. Thank you. REAP versus NCRNC. Okay, and respondent? Okay, 5, 2, and 5. Commercial tenant versus building service. Okay, I'll give you each 5 and 2, and we'll see how that goes. People versus Joseph Green is submitted. People versus Charles. Respondent? Do you still want to argue? We'll give you 4 minutes, and the other side is a submission, okay? Villanueva versus National Freight is submitted, and CC versus New York City Health and Hospitals is also submitted. So the first case for argument is Gonzalez versus Daily for Housing.
Good afternoon. May it please the court. My name is Daniel Kotler for Defendants Appellants. Our argument in this case is fairly simple. Plaintiff claims sometime after the accident, extended number of years, that her foot got stuck in a crack or a chip in the middle of the step. This is directly contradicted by her admission to emergency responders at the time of the accident, that she simply missed a step.
Well, what about, I know you're probably getting to it, but there is a videotape of this accident, and one of you or both of you put into the record 50 or 60 still photos of that couple-second videotape. So was it your opinion that the plaintiff was walking closer to the right-hand side and that this was supposed to be a chip or a crack in the middle of the stairway? Was that also a problem in this case?
That is absolutely part of this case. There are a couple arguments I make based on the video, but that is certainly part of it, that she claims this supposed chip was in the middle of the step, but the video clearly shows that she is walking, essentially hugging the side of the wall, and she doesn't step on the center of the middle of the step. So how can she...
Counsel, there is a chip on the step, isn't there?
There's expert opinion that was...
No, there's a photograph that shows that there's a defect on the step, that there's a chip, that there are portions of that step that are chipped.
Plaintiff's photographs were taken two years afterwards, but
there's a photograph that was taken by the mother the day after the accident, where it shows that there's a chip, there's a defect on the step.
Without causation, however, Your Honor...
But here's the thing. The step does have a chip, doesn't it?
Does
the video conclusively show, can you clearly see from the video that she does not step on that particular third step?
The video clearly shows that she is hugging the side of
The video shows that she's to the side of the stair, but you don't know exactly from the angle that video was taken where exactly on the stair she is.
I disagree respectively with that description of the video.
Well, then there's a disagreement between you and me, which means that there could also be a disagreement as to which raises an issue of fact as to where exactly she was when she's coming down that step. She's closer to the right, but that does not preclude that she could also be close to where that chipped step is.
To that, I can only ask that Your Honor look at the video a second time.
What does the video show in terms of it's not really a chip, it's that the edge of the step is worn away, as shown in the still photo, in the middle of the step.
That is precisely, Your Honor,
Let him finish his question.
I'm sorry, Your Honor.
Question. But what does the video show in terms of the nature of her fall? I watched the video at least 5 times, and it seems as she comes to that step, it's not a matter of somehow being waylaid by the chip, it's that what the video shows is that she's missing that step.
Absolutely, Your Honor. That's exactly the argument that we make, that it's not... There are 2 issues there. The first issue Your Honor raised is that while plaintiff characterizes this as a deep chip, it appears to more simply be something very superficial. But the bigger question is when you watch the video, and I would recommend taking this frame by frame with a video player because it does help to see it more clearly, it does show that she steps past it, exactly as she told her emergency responders, regardless of the condition of the step. She doesn't step on it. She steps over it and attempts to put her foot down in the air because she simply missed it. She was hurrying down, wasn't paying attention, and stepped over it. So that is a good summary of my arguments, Your Honor. So
I agree that she's hurrying down. That you can, but you can't see from the video exactly what happens because it happens so fast. And as you see it frame by frame, you can see that her foot somehow touches that third step. So does that conclusively establish that the chip had nothing to do with her fall?
I think when you watch the video and you take it carefully and you see that has her one foot placed stably and then she steps the other foot immediately before she falls. She falls as she takes a foot and she steps over and past the step, and that is the cause of the accident, as she steps past it. I can only ask that Your Honor look at the video again.
I looked at it as many times as...
Yeah, I think we've all seen it a lot of times. Okay.
Thank you, Your Honor.
Counsel, you'll have a couple minutes in rebuttal. Let's hear from the respondent. Thank you.
Good afternoon, Your Honors. May it please the Court. Scott Horn, counsel representing the respondent in this matter. It's our contention, Your Honors, that the motion court correctly denied summary judgment under the circumstances because the defendant simply failed to establish that the subject broken stair tread, which is clearly a defective stair tread, was not a substantial contributing factor as a matter of law.
Counsel, the problem I have with that is, even if that's defective, if as it appears from the video, her foot wasn't anywhere near where she says the defect was, how do we get to causation?
I respectfully disagree with the characterization of the video. I don't think the video is...
Do you agree with me that if she does, if her foot, if we see that, if we conclude that the video shows her foot was nowhere near the center of the step, do you agree that you have a causation problem?
No, Your Honor. What I would argue is that if her foot missed completely, just stepped over the step, she never touched the step, that would be a causation problem. But based upon that video, that's not what it shows. And more importantly, her testimony fully comports with what we see in the video. From the angle of that video, you can't tell whether her foot makes contact with that step or not. Certainly not as a matter of law.
But in her testimony, she also said that there was no handrail on the side she was on. But in the video, it's clear that there's a handrail on both sides.
Well, I know that she
Isn't
said...
that a problem?
I know that she said she didn't hold on to the handrail.
No, she said there was no handrail.
Okay, but even if she did, that certainly doesn't call into question her recount of how she walked down the stairs, right? You may have asked her whether the light was yellow or white in the lobby, and she may not have known that either. The fact of the matter is the salient facts to this accident are fully supported by the video.
What about, there seemed to be some contradiction about whether or not she was holding a cell phone. She said, I think it was my mask, but this was April 2020, but not even withstanding that, I looked at the video and she was wearing her mask, she was holding her cell phone. And seemed to be looking at her cell phone as she was walking down the step. I admit the whole video that we've all watched so many times is only a couple seconds, I get it. But can you address that also?
Sure, Your Honor. To the extent that they're relying upon the concept that she had a phone in her hand and possibly was looking towards the phone, it's simply an issue of comparative fault. It's not a question of sole proximate cause as a matter of law, particularly when the video clearly shows her stepping on the broken step.
Counsel, in your memorandum of law, don't you describe the video as useless, quote unquote?
Whether it's useless or not in the context
It's only useful if it helps you, counsel? I mean, that's the obvious question. You're using the video, but you also say it's useless, so what is it?
It's not a question of me using the video so much as taking issue with the way that the defendants are using the video. The defendants are using the video.
You just stated that the video clearly shows her stepping on the defect. Now, I understand you're going to make arguments about it, but how you can say that that video clearly shows her stepping on the defect. I mean, it's just
I would say that
an incredible statement.
the video shows her with her foot stepping down onto the third step, not necessarily the defect, because the defect's not depicted clearly in that video. It's a blurry video. I agree with Your Honor that it's more of a worn stair tread, and it's worn to the extent of 3 inches at the nose of the stair tread.
I mean,
That was her testimony.
even if you assume that she did step on that defect,
Yes.
it doesn't explain how that defect caused the fall unless she missed the step, because what about that defect would cause her to fall like that?
The fact that the step is missing at the front of the tread.
There's not that much of the step missing that if you're stepping on this step, you're going to fall.
So-
That's what makes it so hard to accept the version of events that you're trying to present.
I respectfully disagree, Your Honor. If there's 3 inches missing at the nose of the store tread, that's 25%. She testified that she put her foot on that broken tread and immediately pitched forward and went flying down the stairs.
And is it,
I don't think the still photos show 3 inches missing.
That was her testimony. The photos are from across the lobby, and it's grainy. It doesn't depict the...
So do we accept her testimony if we have a photo showing which contradicts her testimony? That's an issue of fact?
I'm sorry, I missed that, Your Honor. So she's saying the defect was 3
If a photo
inches.
shows one thing and she testifies to something else, that creates an issue of fact?
If it's a difference between 2 inches and 3 inches, I would say yes, absolutely, Your Honor.
and a small question, is it your claim, which foot are you claiming she stepped on the relevant step with? The right or the left?
I don't think it was particularly clear one way or the other
I
from
would
the
just like to know what
video.
your position is as to which foot she stepped on the defect with.
It appears that she put her right foot down on the step first and then her left, and then that's when she pitched
You
forward.
put both feet on that one step.
It appears
Is
that
that your,
that may
is
be-
that your position?
I'm sorry, Your Honor?
That's your position?
From looking at the video, that's what it appears. Again, I don't think the video is crystal clear. I, too, watched the video time and time again, and am still unclear as to what it actually depicts vis-a-vis her feet, the defect, and the stair. But what it does show is that she fell on that step, and in accordance with her testimony, she said she felt the defect under her foot. She specifically testified to that at page 91 in the record. I felt it under my foot, at which point she pitched forward. And I would respectfully submit that if there's a chunk of the tread at the nose missing, it's perfectly reasonable to say that putting your foot on that and then pitching forward is exactly what's going to happen. Thank you, Your Honors.
Okay, thank you, counsel.
Briefly, Your Honors, I think the essential issue here is precisely it. Even if she stepped on this, even if there's some defect, she stepped and then she falls after she stepped down and as her foot is stepping past. That accident isn't caused by whatever condition is there. It's caused by her stepping past the step, which is what the video shows. Very briefly, plaintiff began to bring up, I believe he started to bring up building codes after the court sort of moved the conversation away from that. Our papers do talk about this is a 1915 building, so that doesn't apply. Beyond that, I think the court has our argument.
Okay, thank you.
Thank you, Your Honors.
Thank you both. Have a nice afternoon. The next case for argument is J.G. Infant against St. Luke's Roosevelt.
Good afternoon, Your Honors. My name is Mitchell Giddin for the appellant. This is a case that involves causation. The defense at oral argument premised its argument that causation is only at stake. The expert for the defendant, Dr. Edwina Popek, who's a pathologist, does not speak about the standard of care. I will address the standard of care if any of Your Honors has any concern that there is even a prima facie case made.
Well, one of the things I was concerned about was the situation which happened when the mother, this is the right case, right? Where is this where the mother went to the hospital on September 25th?
That's correct.
Sorry, we have 4 mid-males on today, so I want to make sure we
Okay,
have
for
the
sure.
right facts on.
Yep.
But the mother went to the hospital on September 25th. There was a problem. They said, we're going to transfer you
Yeah.
to the St. Luke's Roosevelt.
Yeah.
Different West Side campus or whatever.
In Midtown, yeah.
Midtown, and she claimed she was waiting for several hours for an ambulance to come. She finally went home, never went to the hospital. Somehow managed to she missed her October.
She missed the October 1
October
appointment.
1st, and there was a note in the record that said, very important.
It's urgent.
Right. A nurse must call. She claims she never got any call, and she got a date to come back in November. In the interim, on October 11th, she goes back to the hospital and is in such distress that they need to deliver the baby immediately. And your doctor, expert, Dr. Brickner, indicated that there could have been some causation exacerbated by the fact that this timeline occurred.
Exactly, because Dr. Popek says that it's he says that it's, Edwina Popek says that this is a cumulative, it's a chronic process. Also says that it wouldn't have mattered if delivery was earlier, which means that the appearance of the fetus, okay, and the uterus and the placenta on a sonogram, okay, would have shown the same condition, essentially, that you see on the date of delivery, the 11th of October, anytime after September 25th, and certainly anytime after October 1st.
Wasn't part of the problem they couldn't really detect this on the sonograms, and they really weren't sure of the situation until the delivery?
The massive perivillous fibrin deposition, MPFD, cannot be diagnosed except on pathology exam. But the intrauterine growth restriction can and was. As early as the 25th of September, they had lab results that there was a maternal serum alpha fetoprotein.
Whatever the responsibility of the defendants, but the fact that the plaintiff leaves on September 25th, the fact that she misses her appointment on October 1st, how does that factor into where liability lies on this?
Well, assuming, as I think we need to...
Let me just, if the defendants did something wrong in not calling her to come in, does that mean after October 1st, does that mean that our failure to come in on October 1st doesn't count for anything?
Yes, it doesn't count for anything because I don't think we can attribute negligence if that's what it was. It could be forgetfulness. The reason she missed it is not even in the record. But I think the key is the loss of the chance of a better outcome because we know that this was a progressive process that suffocated. That's the defendant's experts' word. Suffocates the placenta.
How are you to evaluate this better outcome? I mean, at some point, if you were to prevail at a trial, how do you determine what this better outcome might have been? Isn't it just speculation?
I don't think so. I think the difficulty is in quantifying. Okay, I'll just...
Did in connection to that, your experts say that NICU therapies administered earlier than later...
The baby is better off getting treated in the NICU than being asphyxiated.
So how does that get quantified?
Well, I don't know that it can be exactly quantified. It can be generally quantified, I mean, or even estimated, if you will. On the history of this admission that you'll see, page 321 of the record just sums up what the condition of the fetus when the mother came in and at the time of delivery. It showed reverse end diastolic flow, a thickened bowel wall. That bowel wall didn't thicken in 2 days or in 3 days. Cystic changes in the placenta. That is indicative of the Perryville and Fibers deposition. It's not the same thing, but it's cystic changes in the placenta. That didn't happen in 48 hours. The cerebral ventricles could not be seen. That's the hemorrhage, brain hemorrhages, diffuse, that were shown 8 hours later on a CAT scan to be all over, intraventricular, intraparenchymal, subdural, subarachnoid. Now, so, you know, anytime we have, I'll reserve, I guess, for rebuttal if that's acceptable. I'm not in the middle of answering a question right now.
Okay, I would appreciate that.
Okay.
Let's hear from respondent, and then we'll certainly hear back from you. Thank you.
Good afternoon, Your Honors. My name is Elliot Zucker from Aronson Rappaport Feinstein.
If you want, you can take your mask off, that's okay.
Oh, sometimes I even forget it's there.
I know.
So how do you deal with the fact that the chart reflects that on October 1st, there's a note that this is urgent, she should be called back, and it seems uncontroverted that she was not called back?
At the very least, there's a question of fact that she was called back, but that's not, the question really is.
Sorry, what in the record establishes a question of fact about whether she was called back? I didn't see.
I don't think there's anything in the record that just establishes it one way or the other. I think it's just silent on the issue. In any event, I think the key here is causation. Okay, the question is,
you know, for these purposes, I accept what you say. It's a question of fact, was she or wasn't she? But let's say she wasn't called.
okay, let's say she was.
Assuming.
Right, and let's say that there are, let's say she wasn't, okay? The still question becomes what difference it made in terms of this child's outcome. It's a causation case.
Yes, but Dr. Brickner says it would have made a difference, that the MPFD could have been mitigated, if not, obviously.
Again, but what does he
Let me
base-
finish the
Wait,
thought,
wait,
Counsel.
yes, please let.
It could have been mitigated by an earlier delivery, and that's the question of fact that would be for the jury.
The question is what he bases that statement on, okay? It's very nice to say in the abstract that earlier treatment is better. Earlier treatment is almost always better. The question is what difference does it make and what evidence is there in the record to support that? Here, my expert was a pathologist. He was able to look at the pathology, examine the degree of calcifications, and say that 2 weeks earlier, there would have been no difference. The plaintiff's expert did not look at that pathology and was not a pathologist who could have opined even if he wanted to. That's the difference, okay? And let's not ignore, you know, which is sort of the elephant in the room, which is the prematurity here, okay? This child was already born very premature. By my calculation, I think it was 27 weeks. They're suggesting that the child should have been delivered before that, 24 weeks, 25 weeks. Nowhere do they suggest that whatever problems that this had would have been, they don't know how to compare it with the problems that then would have been associated with delivering a child who's barely on the cusp of viability.
That sort of prematurity would have had a different set of problems.
Exactly. So when you talk about quantification, when you asked about those questions about quantification before, Your Honor, I realize that in loss of chance cases, you don't have to have, you know, exact percentage qualifications, okay? But you can't ignore the record either. You can't ignore that their proposed solution would have subjected this child to a whole host of problems that didn't exist by waiting a little, okay? You know, if the result of a delivery 2.5 weeks earlier was going to be death, you know, you can't just ignore that.
Counsel, Dr. Brichter's affidavit suggested that the treatment modalities available for an infant delivered early would have in fact mitigated the harm from MPFD, and your expert didn't address that at all, did he?
Well, again, my expert,
I mean,
unless we submitted
do you agree with me that your expert did not address how the infant could have been treated if delivered early?
No, because my expert took the position that this made no difference at all. And again, the prematurity argument wasn't really, we would have had to put in a new expert in our affirmation and reply.
But you didn't do that?
No, we didn't. So again, without the proof in the record from the pathology, from someone looking at the pathology, that this would have made a difference, I think their case fails. And from the ignoring the parts of the record that has to deal with the prematurity, the case fails. And that's on top of the speculative question about whether or not she had returned to the hospital earlier, would she have opted, if given the choice, for a premature delivery just on the cusp of viability? There's no proof of that in the record either. And without that, I think the case fails. Thank you, Your
Okay,
Honors.
thank you very much.
Your Honors, I don't think that the delivery would have been on the cusp of viability if it happened any time after October 21, because in 2010, 26 weeks, even
Does your doctor address that? I don't.
Yes, yes,
in
yes,
his
yes. And it's
affidavit?
very simple that when this baby was being deprived in utero of oxygen, nobody's disagreeing with that. Dr. Popek makes that point. Our expert says, you know, you get
What's your
more.
response to his point that your expert didn't look at the
He read,
the pathology?
yeah, he didn't look at the slides because he's not a pathologist, but he read the report. Not only did he read the hospital record. We don't disagree with the MPFD diagnosis. That's why we didn't even use the pathologist that we had engaged, as counsel points out, for some reason in their papers below and in the brief here, that there's some nefarious reason we're hiding something. I want to rely on Dr. Popek in this case. The difficult thing, I think, if there is a difficulty, is what the court said was speculative, was what would have happened. Now, one argument's made, you can't take the baby at 26 weeks, it would have other problems. That goes to departure, okay, which they didn't make that argument on. Causation is the issue. If mother came back, as she should have, and she didn't come back to the hospital because of the departure, because of the hospital's negligence, she didn't have the opportunity, and the baby didn't have the opportunity to get a better outcome. And Dr. Popek says the MPFD's debilitating characteristics on the fetus, which were not changed or impacted by any alleged or perceived delay in delivery. So therefore, a week earlier, a 2 week earlier, he wants to have it both ways. A week or two earlier, you would see the same thing that the doctor saw on the 27th, which necessitated prompt delivery. Now, as I tried, we had limited time, really, I guess, to argue before the Supreme Court, but I would just submit that the case law on loss of chance, if Your Honors don't even find that there was a direct cause of injury, the loss of chance is almost is unavoidable here when we know, maybe more likely than not, what would have occurred had there been no failure to bring the mother in when she should have been brought in. Thank you, Your Honor.
Okay, thank you, counsel. Thank you both. The next case for argument is Martinez versus Ravi. Good afternoon.
Good afternoon, Your Honors. May it please the Court. My name is Amy Bedell. On behalf of defendants, appellants Venkata R. Ravi, Medanova Physicians, and Ravi Physicians. It is the defendant's position that the lower court erred in finding a question of fact was raised. While it did find that the question was close, it erred in denying our motion based on a number of factors. Number one, as the lower court pointed out, the expert's opinion was based significantly upon the deposition testimony of Mr. Martinez, the decedent. In his deposition testimony, as we pointed out at length in our brief, he testified that from 2012 and continuously thereafter, he had a number of complaints which the expert claimed was associated with pancreatic cancer. Now, the issue there is, by putting the complaints as arising in 2012 for a pancreatic cancer that was not diagnosed as metastatic until 2016, it creates an impossible conclusion that this Mr. Martinez had noticeable signs and symptoms of pancreatic cancer 4 years before he was diagnosed. Now, we know that pancreatic cancer is an insidious, aggressive disease that is normally not diagnosed until, one, it's either incidentally found on a scan, or two, the symptoms, like here, when he arrived in July of 2016 at Mount Sinai Hospital, had these debilitating symptoms of 10-10 abdominal pain. And this is a record that is very important here because the plaintiff ignores it. He had only had abdominal pain for 4 days when he arrived at Mount Sinai Hospital, and he had a loss of appetite for 2 weeks. Meanwhile, the testimony of Mr. Martinez is that he had beige-colored stools since 2012 and continuously going forward.
Well, one of the things in this particular case is that the plaintiff actually alleged in their bill of particulars a claim for inaccurate record keeping, and sort of connected to that, saying, I kept telling them some of these symptoms, and I don't know if what they wrote down or what they didn't write down, but I told them these symptoms and they didn't really react to them. How do you address that?
Well, the issue there is, one, they attack the medical records because that's what they can do, okay? There's none of the other provider records have those complaints either. The plaintiff
So
doesn't.
Bronx Heart Medical, right, is one of the other providers, and
Correct.
those records do not reflect the complaints made by the decedent, correct?
That's absolutely correct. And then when he gets to Mount Sinai Hospital, that's when the types of complaints that are indicative of pancreatic cancer first show themselves. And it shows that when he does have those types of complaints, he goes to the emergency room because that's how bad they are, unfortunately, with this disease.
You'll have a few moments. First of all, we'll hear from the co-defendant, and then you'll have a few minutes on rebuttal. Thank you.
Good afternoon. May it please the court. Samantha Quinn for defendant appellant Marissa Leonardo, physician's assistant. Ms. Leonardo was an employee of co-appellant's practice, and therefore I'm going to try not to overlap too much. We did use the same expert and made many of the same arguments. One of the issues that my co-counsel didn't get to was the issue of proximate cause. There are two aspects to proximate cause where plaintiff's argument fails. First and foremost is something that she touched upon, which is that the idea that this pancreatic cancer was diagnosable for 4 years prior to the actual diagnosis at a time when the outcome could have been different. But that expert never acknowledges the fact that the very symptoms that he is stating would have led to this diagnosis are by definition late-stage symptoms. So the proximate cause there, it doesn't make any sense. These symptoms would only be present on advanced disease, and this is why pancreatic cancer is so difficult. Secondly, one of the allegations is that there was a failure to diagnose, a failure to refer Mr. Martinez for a gastroenterological workup, and that this was a causal factor in the failure to diagnose his pancreatic cancer. Yet there was a referral, and there were multiple advices and referrals that he did not follow. In fact, we listed them on page 50 of our appellant's brief. There were 5 no-show appointments, the second of which was January 13th of 2014, ultrasound gastroenterology. He did not follow advice. He was continuously reprimanded for not losing weight, not following advice. There was a cardiac catheterization recommended, and he said, no, I don't want to do it. I want to, give it a year, lose some weight. So the notion that he would have actually followed the advice, the causal link is completely missing. He was given that referral and didn't go, so why should we assume that there would have been any different outcome if a referral for a workup as opposed to a screening colonoscopy was given? If the bench has no questions, I will defer for my rebuttal. Thank you.
Okay, fine.
Good afternoon. May it please the court. I'm Tanya Pagan for the plaintiff respondent. Your Honors, the defense would have this court believe that 12 days after Mr. Martinez last presented to them that he presented with stage 4 pancreatic cancer at Mount Sinai, that they had no idea he had because they claim he had absolutely no symptoms, no presentation, no nothing for 4 years that they virtually exclusively treated him. That's what they're asking this court to believe.
One pillar of your case is that we give credence to his statements that he did complain about various indicia of pancreatic cancer. But given that at his EBT, he displayed all kinds of memory lapses, why should we give credence to that? Why should we not instead believe the records?
Your Honor, there are credibility issues for the jury to determine. My client, while he was alive, undergoing chemotherapy and radiation while he was grilled over the course of 3 days in a deposition, he had some issues with memory. He had to stop his deposition. And these depositions were videotaped. That's evidence in the record from the jackets of the transcripts, and there are repeated stops and starts because my man, Mr. Martinez, needed a break while he was being questioned, while he was undergoing chemotherapy. So the defense would have this court believe that under those conditions.
But doesn't the approach that you take here, that if the patient comes in and says something which is at variance with the record, that we pay no heed to what the record says and we have an issue of fact?
There are many issues of fact, and just as the defense is questioning the credibility.
How do we get past what the record says? I mean, if on many different things someone testifies at a deposition, well, what the record says is not so. What does the record mean going forward?
Well, Your Honor, it's a problem for the defense because in this case, we have a medical facility that, according to my testimony.
Let me put the question a little bit differently. So going forward in any medical malpractice case, if a patient comes in and says, well, what the record says is not accurate, we have an issue of fact and summary judgment should be denied.
Your Honor, it's got to go on a case-by-case basis, but that does raise a question of fact.
Basically, that's what you're saying. Basically, that's what you're saying.
Well, in this case, we're certainly saying that, Judge, because the records themselves are so unreliable, as we've demonstrated in the motion court and in our brief, and our expert goes over it very carefully, that the records by the medical providers themselves are so contradictory in their each individual progress note that they're unreliable. So you have instances of, for instance, the PA Leonardo in January of 2016, seeing my client and documenting shortness of breath, and that is what prompts the referral to the cardiologist. In the cardiology records in 2016, February of 2016, Dr. Aota from Bronx Healthcare is memorializing that my client is complaining of precordial pain. And my expert describes that that's pain between the stomach and the chest. And their record documents that that pain had been going off and on for several months. There is nothing of that documented in the Medanova chart. How do you explain that the PA sees him a week before that visit, documents shortness of breath only, and in that range of systems that those providers described to me was simply a cut and paste, note to note, note to note. They're inherently unreliable and raise questions of fact. In that regard, Judge, the claim that there's nothing in the record that corroborates what Mr. Martinez testified to concerning his complaints is not true. We've got the Bronx Healthcare record in February of 2016 that's in the record that documents the precordial pain. We also have the May 2016 catheterization that the defense doesn't want to talk about, documents him being on Prilosec, as well as having GERD. My client was not seeing multiple providers for years. He was seeing Medanova physicians virtually exclusively from 2010, only them. So these are multiple questions of fact, and we're asking this court to affirm the Supreme Court.
Thank you, counsel.
Good afternoon. I will address some on rebuttal and will leave the rest to my co-defendant. Just a couple of things. First of all, the claims regarding the medical records, as I touched on a little bit earlier in the argument, the claims as to what is in the history presenting illness, what is in the range of system on a couple of notes, one of them being in 2012, one of them being in 2013, they're immaterial. They have no basis for rendering the entirety of the medical record unreliable. The GERD and the Prilosec entries, those were made in the Mount Sinai record when Mr. Martinez was having a cardiac catheterization. We have no idea where that came from. It's a speculative that has anything to do with pancreatic cancer. And number two, when a patient has a cardiac catheterization, if he had a debilitating stomach pain or these other ranges of symptoms like he had when he arrived at Mount Sinai, he would not have had a cardiac catheterization, number one. And number two, the other thing that the plaintiff mentioned, 12 days after his last presentation to the Metanova practice, he appeared at Mount Sinai. Well, even if he did have that 12 days before, what could the Metanova physicians had done at that point 12 days earlier? They would have referred him to the hospital, which is where he went. And most importantly, the plaintiff is asking us to disregard all of the medical records in this case. The Mount Sinai Hospital record, it is our position, is one of the strongest. The Bronx Heart Medical Center records, where repeatedly abdomen soft, non-tender, no acute distress exhibited throughout the records. And again,
But are you suggesting that we should just disregard the discrepancies within the record?
no, Your Honor, I'm saying that those discrepancies are not material.
Thank you.
It's the plaintiff's position that the defendant's records are completely unreliable based upon plaintiff's self-serving testimony, which was elicited mostly on leading exam by his own attorney. The discrepancy in the record regarding P.A. Leonardo about the precordial region can be explained. There was a 10-day lapse between her visit on January 29th and the visit on February 8th. The precordial region is commonly described as the chest area over the heart, not the abdomen. And Dr. Itati specifically documents at that visit that there was no abdominal pain, and she did a completely benign abdominal exam during that visit, which is at the record at page 1540 to 41. And even ignoring the review of system entries, which consistently noted that in our record the decedent denied abdominal pain, there are numerous notations of complaints actually made by the decedent, each of which was assessed and acted upon. So in order to buy plaintiff's theory, you have to believe that the only complaints that were ignored and not recorded were the ones that are required for the plaintiff to establish liability in this lawsuit.
Why was the plaintiff referred to see a gastroenterologist?
A screening colonoscopy in December.
Yeah, why was that?
2014. Because of his age.
Simply, not because of any complaints that he had made?
No. And I would like to point out, too, that there was a 26-month period during which preceded this January 29th visit. 26 months during which he only came to the practice once, and there were 5 missed visits. So there's also a history of noncompliance, which is very important in a failure to diagnose case. Thank you.
Okay, thank you. Thank you all very much. The next case for argument is Golden Nugget versus Chan.
Thank you, Your Honors, and good afternoon. This appeal is taken from a summary judgment order that was entered on a motion filed just days after we answered the complaint, before a preliminary conference was held and no discovery was taken. In support, Golden Nugget submitted an outdated answer that lacked the critical affirmative defense that gave our client the basis for defending the claims. And it was relied upon in the court in error. And it's significant because those defenses serve the basis as why discovery was important and why Golden Nugget was not entitled to summary judgment.
Counsel, could you explain how the plaintiff's alleged violations of the CCA are relevant to your client's losses?
Absolutely, Your Honor. So in New Jersey, under the Casino Control Act, games are only authorized when they are conducted in strict compliance with the Act. Any games that are not in compliance with the Act are unlawful. And there's also an implied covenant in any gaming contract in New Jersey that all parties will abide by the Casino Control Act. Now, the questions that was raised by the defendant in this case was, one, that Golden Nugget was using non-compliant dice for two reasons. One, that the dice were being scribed, and the Casino Control Act regulations require that the texture and surface of each side
We know the non-conforming aspects of the dice, counsel.
I'm sorry?
We know about the non-conforming, or alleged non-conformities, but do the alleged non-conformities have to affect Mr. Chan's odds at the craps table?
Absolutely not. And the reason being is that the purpose of the Act, and this is specifically stated in the Act, is to ensure the public confidence in the credibility and integrity of the gaming industry. And that is why the regulations must be strictly adhered to.
So that also, you're saying, is also a defense to the other causes of action in the complaint as well?
Are you referring to the bad check?
Yes.
Yeah. So the problem with the bad check claim, and I think this gets to the heart of the Justice's decision, the Supreme Court, was that her opinion basically dismissed it and said, you know, you've submitted all this evidence of illegality, but what does that have to do with the fact that you issued a bad check? And the problem is that the claim of issuing a bad check, it's governed by the UCC. It's Article 3. It's a commercial paper case. It's not a larceny case. And we've briefed this extensively, but the point being is that any defenses that our client had on the underlying obligation carry over to the defense, to the enforcement of the underlying instrument, the instrument that was dishonored. It's not like just because the defense or the claim is being brought on the instrument, you lose the defenses on the underlying obligation.
Your point being that if the game was not complying with regulations, that the fact that your check was no good would be excused?
We'd have the same defenses. So yes, it would be excused because the underlying obligation would be void and unenforceable as a matter of law.
Your contention would be he doesn't owe the money.
Absolutely.
So therefore, you can't collect on this check.
That's absolutely correct.
So are there are currently cases that are before the gaming authorities to determine the legality or not legality of the scribing and of the translucency of the dice, something like that?
Yeah, so let me get into that issue. There were several patron complaints filed against Hard Rock and Golden Nugget. In Golden Nugget, we alleged the non-transparency of the die and the scribing issue. In Hard Rock, we only alleged the scribing issue. The DGE said that scribing was not a violation of the Act. We've appealed that, and the appeal is ongoing.
So that's in the New Jersey?
That is in the New Jersey Appellate Division, correct.
Okay.
In Golden Nugget, the patron complaint was administratively terminated. The DGE has decided not to review that any longer. Now, if you read the Gemico case, which we've cited, and the other cases, Campione, what they've essentially said is that the courts may defer to the DGE for an interpretation, and as was done in Gemico, the DGE just said, we're not going to touch this, and the court took it upon themselves to interpret the Act. That's essentially what happened. And so the framework is that the court may defer to the DGE. If the DGE refuses to act, then the court has the discretion to interpret the Act for themselves. But to date, the Division of Gaming Enforcement has issued no ruling on Golden Nugget's practice of scribing the dice. They've only issued a ruling and investigated Hard Rock's practice, and they've issued no ruling on...
Why, I mean, just out of why would it be any different depending on what, the casino? I mean, isn't it the practice? It's New Jersey, they're under the same regulations.
I think it would be a stretch to say that they were different. I think the point, though, is that Hard Rock's practices were actually observed. The dice was weighed, measured, balanced, et cetera. Perhaps theoretically, Golden Nugget engages in the practice differently that may impact the decision. I agree that it's a stretch, but I do, the remaining issue that has not been interpreted by the DGE is whether the dice were transparent.
I have a question about that. It seems to me that your argument about the transparency or opacity of the dice depends in large part on the photographs. But those photographs were only authenticated to the extent you can call it authentication, by an affirmation of counsel, not by your client or anyone who was present at the casino. So why aren't those photographs totally irrelevant?
So I don't think it's just the photographs. We all submitted the patron complaint.
Could you address the photographs?
So the photographs are, my reading of the Zucker case from the Court of Appeals is that documentary evidence from
Counsel, how did you authenticate that these were photographs of dice in the Golden Nugget Casino?
They were authenticated by the attorney affirmation, Your Honor.
Okay, so that person, there's no evidence that that person had ever been to the Golden Nugget Casino, right?
No, that's correct.
So they're not authenticated as coming from that casino, correct?
Well, they were authenticated by the patron complaint that we submitted as well, because
is that sworn to?
The patron complaint, I mean, it's a legal pleading.
Is it sworn to?
No, Your Honor.
Thank you.
Okay, why don't we hear from your adversary, and then you'll have a few minutes on rebuttal. Thank you.
Good afternoon, Your Honors. John O'Brien, Berlani Nussbaum writes this for the respondent. Your Honor, every question the appellant raises is trying to shift the burden back onto the Golden Nugget to independently prove that it is compliant with an extremely tightly regulated industry, an industry that is regulated exclusively by the New Jersey Division of Gaming Enforcement and by the Casino Control Commission. He's asking for discovery to privately enforce New Jersey gaming regulations, which is exactly what he is not allowed to do.
But isn't the question not private enforcement, but whether the failure to comply with those provide an affirmative defense to a contract where the implied provision in the contract is that both parties are complying with the Casino Control Act?
I think that's a fair characterization of his position, but it's not a fair characterization of the law. He doesn't have a claim in New York. There aren't any New Jersey cases that allow you to raise your hand and say, well, actually, I think all of the dice.
But the Marina case specifically says contractual agreements governing casino gambling in New Jersey include a provision that both the parties agree to abide by the CCA. Why isn't that sufficient? Why aren't you bound by that?
It is true that both parties are bound by the implied agreement to follow the CCA. But I think if you look at the Marina case, you have a very different scenario. You have one in which the Borgata brought claims against Phil Ivey, a professional gambler, and that case lists, I think it's 26 paragraphs detailing this is the scheme he used to cheat at Baccarat. Mr. Chan hasn't raised anything like that. They explained why he changed the odds in the game to create an unfair game outside of it. And if you look at any of the other cases, you have cases in which a specific game was affected by a violation or an alleged violation or some other act that is controlled by the Casino Control Act. That's not what Mr. Chan is saying. Mr. Chan is saying that these dice that you use, that the Division of Gaming Enforcement has seen innumerable times, that they can independently measure at any time, that are weighed and measured before they ever reach the floor in full view of everyone by a micrometer and a balancing steel and a measuring stick. The Division of Gaming Enforcement got this wrong after all of these years. They shouldn't be approving these dice. They shouldn't let these dice be played with. That's what he's saying. He's saying that all of the dice and all of the games all of his losses should be wiped out. And he's doing it on an affirmative defense with just 2 lines that's not articulated in any of his briefing as well. That's the problem. You can't point to a technical violation and wipe your hands of your breach.
And presumably, there are other people with markers that are due and owing today arising from losses at the craps table, and they would also be able to say the same thing if Mr. Chan is correct. In other words, then you'd wipe out all the, they'd be allowed to walk away from those debts.
That's exactly correct, Your Honor. I think the problem here is that you would have, under Mr. Chan's theory, you would have a New York court stepping in and saying, actually, I think you can't enforce any of these agreements unless you are allowed discovery to, I guess, privately audit all of the practices of the Golden Nugget Atlantic City. But once you're in that territory, now you are exclusively in the domain of the Division of Gaming Enforcement. We should know that this is a tightly regulated industry in the sense that not just are there many, many regulations, which we've cited and which all had a chance to become familiar with, but the Division of Gaming Enforcement has inspectors at casinos all the time. You can complain directly to them. They're in their description and their website. They describe themselves as being there around the clock. And you have a patron who was there frequently for years and is now saying all of his gambling losses are invalid, not just at the Golden Nugget, but at the Hard Rock, because I think I read this statute differently than the DGG reads it. And that is not the appropriate role of, certainly not the appropriate role of New York courts, but that's particularly not the role of courts generally, particularly when you have something raised purely as an affirmative defense. Justice Bluth got it right when she said, when she read their argument and said, I understand that you're arguing that there's technical violations of the Casino Control Act, but what does that have to do with your bouncing the check? You admit you signed the agreement, you admit you got the chips in exchange for the checks, you admit that you bounced the checks. There's nothing left to decide at that point.
Can I ask you about the use of your term technical violations? When is a violation of a gaming regulation substantive and when is it technical? I don't understand what makes these a technical violation.
Well, if you look at some of the New Jersey cases, they have a useful description of it. Decker v. Bally's, Marcangelo v. Boardwalk Regency Corp. So one of them involved removing slot machines when it had paid out a certain amount. Another one involved whether the signage complied above a I believe it was a slot machine as well. And so what those courts have said is you don't have a right to go in and find what they all refer to as a technical violation. What all of the cases which are typically brought, Your Honor, I see that my time is up. If I could just answer your question.
Answer the question. It's okay.
What all of the cases in which we've cited in any of the briefing go forward, you have a plaintiff alleging violations and common law claims and an explanation for why that violation rendered the game unfair. What you're not allowed to do is say, well, I think the coloring is off here. Therefore, all of this gambling I've done for years, not just one game, one time, but frequently for years, is somehow invalidated. And if
Okay.
I was up, thank you, Your Honors.
Counsel, you have 2 minutes.
Thank you, Your Honor. So I'd like to address a couple of points raised by my colleague. The first is the distinction that we just discussed between a technical violation and a substantive violation. And I think that my colleague really misinterprets or misstates the holdings in the cases that he cited. Decker involved a case. First of all, the case was decided 4 years before Campione, before the holding that said that a CCA violation can give rise to a common law claim, but will not stand alone to be its own, its own private right of action. And that's the distinction between Decker, where there was the they sought to bring a private claim based purely on the technical violation, but there was no underlying common law principles on which they could attach that
So,
claim.
counsel, what kind of discovery would you envision you would have in this case?
Well, I think they've pointed it out in their opposing brief, Your Honor, and that is we would at least be entitled to inquire whether the dice were indeed approved by the DGE. They would have records of it because they're required to maintain it by the regulations. So I said it in my brief. If, in fact, the DGE reviewed and approved those dice, then yeah, our claim.
Then the case is over? Then that's it?
I would say our claims for the non-transparent dice is certainly impacted. I think that we would be entitled to potentially discovery as to whether or not the practice of scribing the dice impacts the odds or the fairness of the game.
But hasn't that already been determined by the
DGE?
By DGE?
It's been, the DGE purely weighed and balanced the dice. Now, there's two issues with the practice of scribing the dice. By scribing the dice, you've changed the surface and texture of one side of the die.
But I thought that it's already been determined that that's okay.
If we could show through expert, I'm not a casino expert, so I don't know the answers to the questions that we would raise.
I don't think either are we, but still.
But I would say that we would certainly, in addition to exploring the translucence of the dice and exploring the fact that the dice were indeed approved by the casino, we would also explore expert testimony, if it's, or expert evidence that the practice of scribing the dice indeed impacts the odds of the game. Because it's not just about, when you're playing craps, the odds being, each number has a weighted odds for its likelihood of coming out.
Okay, well, we'll take a little further look at your claims here, and thank you both very much.
Thank you, Your Honor.
A little different, I must say, that case. All right, the next case is People versus Rivera.
May it please the court, Abigail Everett for Appellate Isaiah Rivera. I'd like to start with the pepper spray point. Excuse me, let me get my mask out of my earring. The pepper spray point, which was hotly litigated below. Now, this is whether or not the people established that this was a dangerous instrument. This is an essential element of 5 of the 7 predatory sexual assault counts.
Would you consider that to be a noxious gas? Is that similar to that?
I mean,
the judge wrote a decision, I think it was after the trial, am I correct?
Yes.
A very good decision about how there weren't really many, or any maybe, that she could find appellate cases, but she went through an analysis, looked at cases in other states, and she found that this was definitely a dangerous, could be determined a dangerous instrument, and the way that pepper spray was used in these cases, and that was never appealed, correct? That decision is from 2018. That decision was not appealed.
That decision was not appealed. Are you talking about in this case? Because we can't do it. What's the word?
Well, it was
interlocutory appeal.
It was against all 3 defendants.
Right. So what she held after the trial was that there was sufficient evidence because the pepper spray could have choked or...
I guess she reserved on the motions that were made at the end of trial, and this was the decision that she wrote in 2018 relating to that issue.
Right. So she held that it could have had life-threatening breathing injuries to the woman. But the point I'd like to make is that when you're assessing whether a substance is readily capable of causing injury that could have a substantial risk of death, it has to be evidence-based. You have to look at the record to see what the people established and the way it was used in this case. The people here had 3 nurses testify as to the injuries. None of the nurses talked about any potential for greater damage, injury, I should say.
But, you know, the individuals who were sprayed with this pepper spray said that they were in such horrible pain that they couldn't even open their eyes. They were restrained from being able to wash it out. When they did open their eyes were bleeding. When they went to the hospital, or at least one of them went to the hospital, the nurse found that the eyes were bleeding. They had washed it out. I mean, how is that not an injury?
That's certainly physical injury. Substantial pain,
Yes.
which the victims described, is consistent with physical injury, but a dangerous instrument has to be readily capable of causing serious physical injury. And substantial pain or temporary impairment of your ability to see or swelling is not serious physical injury.
Even if it lasted for days?
Well, it didn't last for days. It was temporary. The nurse, one of the nurses testified that the blood vessels that were in the eyes that broke, it's not clear why that happened, but that condition normally is resolved within a few days or at most a week.
Explain to me again, the judge, this issue was raised at the end of trial, the issue about...
Well, it was raised during the trial
and the
as
judge
well.
reserved,
Yes.
right? And she said, I know what the jury found, but I'm going to go back and look at this. And she wrote this long decision, and she
Correct.
ended by saying, viewing the evidence in light most favorable to the prosecution as law requires, a rational trier of fact could have found beyond a reasonable doubt that the defendants, in this case, use of a noxious chemical spray constituted the use of a dangerous instrument which was readily capable of causing death or serious physical injury. She made that finding in connection to, you know, after the trial of this case, in connection to this case. How can this be raised now again?
I'm not sure I'm following Your Honor's question. It's standard to raise a sufficiency or weight of the evidence claim at the end before the case goes to the jury, and it's common
But
for the
her
judge.
decision doesn't preclude you raising it now?
Not at all, Your Honor. That's an issue that this court has to resolve, not only the sufficiency of the evidence on the essential element of whether a dangerous instrument is used, but the court also has broad authority to review the weight of the evidence to make its own independent determination if the evidence supported a finding that a dangerous instrument was used. I do also want to mention that the legislature has enacted a statute that permits people to use these kinds of self-defense maces, even if all that they're using it for defense of is ordinary force. So the legislature has made a finding that people can use this item that has to be found in this case to be a dangerous instrument. You can use it even if your assailant is not using deadly physical force. So the legislature appears to have determined that this is not a dangerous instrument.
I mean, I can't really get that point, because a lot of things that are found to be dangerous instruments because of the way they're being used under the circumstances are still legal. I mean, you could go to a baseball game and play baseball and use a baseball bat, and that's just great. That's not illegal. But when you're banging somebody, you know, when you're hitting somebody over the head or seriously attempting to seriously injury, then it's being used as
Absolutely.
So can a sneaker. So can a lot of things that are just
Right,
fine.
but our point here is that the way it was used in this case, it was not readily capable of causing an injury that has to be a substantial risk of death. It's not enough, of course these women described substantial pain. That's physical injury, but if you can't just speculate that this could have caused a substantial risk of death. There has to be evidence-based, and I submit in this record, you don't have sufficient evidence to support the judge below's finding that there was adequate evidence presented at trial.
Didn't these complainants testify that they were suffocating, they couldn't breathe, they were choking when they were sprayed?
Not as a result of the pepper spray. One of the women was being choked around the neck by hands, and she said that because she was being choked, she was fearful for her life. But that's not on this case.
Wasn't one of them also not only sprayed in the eyes, but also in the mouth when she tried to scream?
I don't believe she was sprayed in the face. There was evidence of being sprayed in the face.
And it
but
went into her mouth, and she
I
couldn't
don't
breathe.
think the evidence
To the
showed
point
that the
where-
spray went into her mouth. I think that the evidence was that it was the eyes that suffered the damage. And in fact, Mahua Z, when she testified, she didn't even, she focused on her choking as the person was on top of her and had his hands around her neck. So I would submit that. I see my light is up. If the court has any question about any of the other points, I would welcome answering questions about the other points.
Okay, thank you. You can do that in rebuttal. Thank you, Ms. Everett.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors. To address the point that my adversary just addressed about the pepper spray as a dangerous instrument, I would say, number one, that Justice Kiesel's decision is an extremely thorough decision, and I would submit very well reasoned. And one of the important points that Justice Kiesel made in her decision was that it's not simply the injury that the defendant caused with the instrument, but also whether the instrument was readily capable of causing serious physical injury, not only in the way that it was actually used, but also in the way that it was threatened to be used. And that was particularly relevant in this case because both of the victims that this defendant attacked, when they tried to resist, when they tried to scream, the defendants who had already sprayed them with the pepper spray and assaulted them in other ways, threatened to spray them more with that spray, and they gave no indication that they wouldn't do that. That there was some limit that they might honor to how they would attack them. They made it quite the opposite. They made it clear that they had absolutely no limits about what they would do. And those are the circumstances in which the defendants were deploying the pepper spray against them. So they were spraying that spray into the face, into the eyes, into the mouth and nose of these victims. And as these victims were struggling for their lives, as they were pleading for the defendants to stop, that they were complaining about how they couldn't see, the defendants told them that if they didn't, if they tried to resist, if they didn't stop screaming, then they would spray them more. So in these particular circumstances, that pepper spray, the way it was used, the way it was threatened to be used, the jury could reasonably find, and did reasonably find here, that that pepper spray was readily capable of causing serious physical injury. And I would also emphasize that the fact that the legislature has seen fit to authorize the use of pepper spray in certain circumstances really only highlights the dangerous potential of pepper spray. As the court has pointed out, there are many substances, many things that can be used as and considered dangerous instruments that are generally innocuous and are not regulated at all. But here, there's something that the defendants used that the legislature has seen fit to highly regulate and to give detailed descriptions about when it can be used appropriately. And here, obviously, the defendants did not use the pepper spray in any way that was remotely compliant with those regulations. And if there are no further questions, from the
I
court.
have a question.
Yes.
With respect to the sentencing, can you address that? The 50 to life?
Yes.
Is this excessive?
I submit, on the facts of this case, Your Honor, this is not an excessive sentence.
Why?
All three of the defendants received sentences, aggregate sentences of 25 to life for each of the victims that they particularly attacked. So the co-defendants in this case received aggregate sentences of 75 years to life, and this defendant received an aggregate sentence of 50 years to life. I would ask the court to consider the proportionality of this defendant's sentence compared to his co-defendants, and given the just horrific, egregious nature of the crimes in this case, the calculated manner in which the defendants plotted these crimes, the callous way that they described what they were doing with each other as they were planning these crimes, as they were laughing about these crimes. They really preyed upon these women, regarded them as really less than human, and they attacked them in a way that reflected that, fully reflected that attitude. And so these are some of the most horrific crimes that I've seen in my years as a prosecutor, and so I believe these sentences are fully warranted. This defendant's sentence is fully warranted. I would also note that the defendant was not remorseful for these crimes, and I think that's an important factor. He admitted, yes, he admitted when he was arrested that he had committed robberies against these women, but he denied that he had raped them. And I believe that reflected the attitude that he and his co-defendants displayed all along, that these women, because they were engaged in prostitution, couldn't be raped. And obviously that's just not the case. But I believe that all of these circumstances together, they demonstrate that the sentences in this case, while certainly the defendant's sentence is a very, very long sentence, I wouldn't dispute that, it was thoroughly deserved in this case.
Okay. Thank you.
Thank you.
Just briefly to follow up on the question about whether spray was put in the mouth, during the argument, I looked at the people's brief. Nowhere in their brief, although my adversary did mention it and answer in talking today, nowhere in their brief did they say that the women were sprayed in their mouth. And I would refer the court to pages, I believe it's 15 and 23 of the respondent's brief. So I don't think that there's evidence that they were sprayed in the mouth. Now, I'd like to talk briefly about the sentence. Again, respondent argues that there was no remorse. Well, if you look at the sentencing proceedings, Mr. Rivera was very remorseful. He expressed quite a degree of remorse from this case. That's not the argument that people should be making, that he wasn't remorseful.
But they say that he didn't express that remorse in the pre-sentencing investigation when he spoke to the probation officer.
But he did in open court. Not only did he, express his remorse for what had happened to the women, but he also asked for the court to be merciful both to him and to his co-defendants. And he thanked everybody who had participated in the process. It was actually quite a gracious statement. I would urge the courts to read that. This is a man who at 34, his prior record was only a misdemeanor possession.
You're asking that the sentences be reduced to 18 to life? Is that your request?
I would ask that the court run the sentences concurrent. Since he's doing consecutive sentences of 25 to life. Also, I would briefly, the DA touched on the question of whether or not his position that he had fully admitted that he engaged in the robberies, but he resisted admitting the rape. If you look at, I would ask the court to think about that in assessing the motion for a new lawyer. You can see that Mr. Rivera is having a hard time trusting his lawyer when, during the course of the plea bargain, when the people offered to let him plead to a B felony, and the lawyer says during the plea bargaining that his position at that time is that he's admitting his guilt of the robberies, but is resisting his, the rape. I don't think that this is a question necessarily of not being remorseful. It's a question of, as he alleged when he asked the judge to give him a new lawyer, he's confused. And I would ask you to find that the judge should have given him another lawyer. It's clear that this lawyer who joined in the motion for counsel to be substituted was acknowledging there was no trust between them. He spoke very harshly about the allegations the defendant, the factual allegations the defendant was making about his representation. And I think the court should have given him another lawyer to give him a chance to think maybe more clearly about the plea bargain that the people are offering, to let him plead to something that all along he was willing to admit. Thank you.
Thank you. Arch Specialty versus Nautilus Insurance.
Good afternoon, Your Honors. Andrew Mandelbaum from Kelly & Curtis. May it please the Court, Arch Specialty Insurance Company appeals from a denial of a summary judgment motion seeking a declaration that Nautilus Insurance owes additional insured coverage to our named insured, a company called Bourdon Contracting, with regard to an underlying personal injury action. Alternatively, Arch takes the position that if Nautilus does not owe additional insured coverage to Bourdon, then Arch also does not owe coverage to Bourdon based
Why
on...
would you not be in?
So there's an exclusion included in the Arch policy that requires an insured, a named insured, to have its subcontractors provide additional insured coverage to it, and if not...
So if there isn't that additional, and if there wasn't an additional insured, then your policy doesn't provide coverage either.
Exactly.
That's what that endorsement means.
Exactly. Now, the position that we took is that Bourdon is owed coverage by Nautilus. Nautilus agreed at some point because for 2 years, Nautilus...
Well, they did provide coverage, right? They did defend, but they did it, they reserved the rights like
right, and in fact, the reservation...
insurance company always does.
I apologize for interrupting you. The reservation of rights was a right to disclaim coverage upon a determination that their policy did not provide additional insured coverage. Now, 2 years after they agreed to defend and were defending and assigned counsel and controlled the defense.
Okay, then they retendered to you.
They retendered to us and advised their own defense counsel that they would no longer pay their bills.
Right.
Now, our position and the position of New York law is that if you are defending an additional insured under a reservation of rights and then wish to seek a determination...
You need to come to the court first.
Exactly. You have to come to the court first and file a declaratory judgment action and say...
So they should have brought the action, but instead you brought the action.
Right. And immediately upon their
But
declination...
that issue, is that, do you contend that that issue is determinative of this appeal?
In some parts, certainly with regard to our claims that they owe...
I mean, it makes their position look not so good, but...
Well, Judge Friedman, if they, at least with regard to our Arch's claims that it should be reimbursed for all of its defense costs incurred from the date that they withdrew the defense through the present, through the determination that there's no additional insured coverage, certainly that can be determined right now, that there is a continuing obligation for Nautilus to defend and to reimburse Arch for any costs that it has incurred since their unilateral determination that they did no additional insured coverage.
Counsel, I have a question. It seems to me that your position relies on the contract between GSC and Bourdon being a 3-page contract, not a 2-page contract. Would you agree?
That's correct. Although,
can you show me what in the first two pages I don't have a problem with. Those are signed by everybody. But can you show me what it is that makes the 3rd page part of that contract?
well, I mean, there is a reference in the first 2 pages. I believe it's page 46 of the record, where it references a certificate of insurance. And obviously, there would be no certificate.
We don't know what that is.
Well, there would be no requirement for a certificate of insurance in the contract were there not an obligation to provide insurance. Why would the contract refer to a certificate of insurance being provided by GSC to Bordeaux?
How does that get you to the page 3 that's attached, which I think is the record at 22?
Page 3 is the, I don't have it in front of me, is the additional insured and indemnification requirements between these two parties. To the extent that Nautilus wants to take the position that it is not included as part of the contract, that is precisely why, after having at one point agreed that it was part of the contract, that's why they defended initially, they would have the obligation to prove that it was no longer.
But counsel, you don't have anybody who was party to that contract actually identifying that page as part of the contract, do you?
Neither side does, I believe.
I mean, we've all looked at this page. I do have it in front of me, and there's no indication that there's no reference on that page to GSC. That, I mean, it does say invoice requirements for Bordeaux Contracting LLC, but it seems like it could have pulled it out of a drawer and stuck it onto this thing and said, oh, okay, good, here it is. Because there's no reference that I see on this unsigned page 3 to GSC, notwithstanding that I know that it's not my first contract insurance case I ever dealt with a personal injury case in my years and years of being a judge, but usually the contractors do require the subcontractors to get insurance that names the contractor as an additional insured. Whether they do it right or don't do it right is what gives you insurance companies so many reasons to come to the court and the appellate division all the time and argue all the different little nuances. But looking at page 3, it's tough to find its connection to page 1 and 2.
Well, if I can just briefly respond to that, and I see that my time is up.
I asked a long question, you can answer.
To the extent that that is an issue, it certainly was an issue when Nautilus accepted coverage.
Somebody didn't read it.
And they reviewed it.
But so what are you saying? Because they said, okay, we accept coverage, they're now bound by it?
Not bound by it, but
stopped by it?
They need to at least make a showing that it isn't, because they are the ones who accepted coverage. They've defended for 2 years, and
but now
nothing has changed. So to the extent that they're now taking a position that there has been some sort of determination, that's relying on extrinsic evidence. The allegations of the underlying action do allege in the third-party complaint that there was such an agreement. So to the extent that there isn't, it's their obligation now, not mine.
Let's hear from them, and then we'll give you each will have time to respond since you both appealed the decision.
Good afternoon, Your Honors. May it please the Court, Katerina Stepnovich for Respondent, Cross Appellant, Nautilus Insurance Company. To respond to counsel's comment regarding whose obligation it is to disprove the existence of additional insurance, it really bears repeating, and this is extensively drawn out in our papers, but as the parties that are seeking to establish an entitlement to additional insurance under Nautilus's policy, it is Arch and Bardone who have the burden to demonstrate that additional insurance preconditions have been satisfied, and therefore additional insurance have been.
If I understood your colleague correctly, I thought what he was saying was that you didn't have a right to just drop your coverage without bringing an action, without bringing a declaratory action, so that we should be ordering you to reimburse those defense costs regardless of whether there's coverage or not, because you behaved incorrectly in just dropping your cover and dropping your defense.
Well, Your Honor, we don't dispute that declaratory judgment is typically the preferential vehicle for resolving a determination of coverage. However, this action is a little bit different from what you typically see. This is not a situation where you have an insured that is abandoned by an insurance company without any sort of notice or without an opportunity for representation. This is a dispute between two insurers, and really it comes down to who's now bearing the burden of these defense costs. So at no point, and this is—
Or they were lucky because at least Arch, who explains that they don't think they have an obligation to defend Bardone either, at least for now is defending Bardone, because you don't know what ultimately we are going to decide.
Of course, Your Honor. Well, it bears repeating that Arch is Bardon's general insured.
I get it, but you heard what he said, and I think I did see that they said there aren't, even though that they provided the policy, they don't think they're obligated to defend Bardon, even though they're in the insurance policy, and they are their insurance policy holder, and I guess they are taking money from them, but that doesn't matter because if they didn't go and get an additional insured with GCS, then they're not responsible. So basically, if we listen to you both, Bardon has no insurance coverage and they got to go represent themselves into bankruptcy. All right?
Well, to the extent that counsel argues that this now shifts the burden, there's no case law to support that. But in as far as counsel suggests that this creates an equitable estoppel situation, equitable estoppel cannot create coverage where there is none to begin with. And this is especially true in the absence of any detrimental reliance or prejudice. There's no detrimental reliance here because we have a reservation of rights that was issued at the very outset, which provided that a disclaimer may later be forthcoming. Counsel also has not demonstrated any prejudice to Bardon whatsoever. There's never been a lapse in defense. Bardon has been continuously defended throughout the course of the underlying action. There has never been any indication that that Bardon's position in defending this action was somehow hindered or somehow changed as a result of the ultimate disclaimer that was issued by Nautilus.
Okay, I'm just telling you, the light got disconnected, so I think you probably used up your 5 minutes. Does anybody on the bench have any questions? Okay, I'm going to time out of my phone until somebody reconnects.
Counsel, actually, I have a question.
Oh, you do?
Did you seek a declaration, for Nautilus, did you seek a declaration below concerning your liability policy and your excess policy?
Yes, Your Honor.
You did that, okay, thank you.
Okay, thank you. You have 2 minutes.
Sure.
So the way things stand now, both motions for summary judgment have been denied, and in a case which seems pretty close, you've been left to a trial. What is the compelling factor here which should lead this court to get rid of that trial? What is here makes the interpretation here so clear that there's no need for a trial?
Well, if the point is whether or not Bardon was prejudiced, and I think that was the point that was just raised by my colleague here, and that prejudice is necessary to prove that they should be stopped from disclaiming coverage here, I think prejudice is clear on its face that if Nautilus is permitted to disclaim, which will follow a disclaimer by Arch, Bardon will have no coverage. So that's prejudice one. There's no coverage here. But the second point is that Nautilus assigned defense counsel and controlled the defense for 2 years, then used, although they dispute this case, used that defense to establish that there's no coverage. And the support for that is actually in the letter that was submitted in disclaiming coverage or withdrawing their funding of the defense, as they refer to it, where they say, as the facts have developed in this litigation, we now have determined that there's no coverage. How can you have defense counsel defending and at the same time answering two masters here? While they're supposed to be defending their insured, they're also looking for evidence that there's no coverage here. And then, if you look at their reservation of rights letter, the reservation of rights letter specifically says, and it's in their brief that I had just read, upon a determination that there's no coverage.
Do you think if we were to conclude, and I'm certainly not saying that we're going to reach that conclusion, but if we were to conclude that Nautilus didn't owe a defense, we're going to order that they should defend because they dropped this defense in the posture of this case?
Well, at a minimum, that the court would order that they owe defense up until the point where there's the determination that there's no additional insurance obligation. But besides that, if there's determination that Nautilus doesn't owe a defense, then, and the court doesn't decide that they do owe a defense, then we would just take a position that Arch also does not owe a defense, and we would be reimbursed until that point, and then both insurers would be allowed to withdraw.
Okay.
Your Honors, to address counsel's point.
To address that point, I mean, if it's clear that you behaved incorrectly in dropping Bordone, shouldn't you be ordered, shouldn't you have to pay for the defense up until the point that it's determined that you didn't know a defense?
No,
Since you dropped them in middle.
Your Honor, our position is that no, that's not the case. Nautilus's actions in providing the temporary defense funding to Bordone in the underlying action served to convey a benefit that Bordone was never entitled to in the first place. So there's no principle of law that mandates Nautilus to continue providing that benefit upon a determination.
But you're not allowed to get off without a declaratory judgment action. Isn't that so?
Had the facts been a little bit different, where it would have been an insured that is now left without their own general liability insurer, I believe that would have been the case. But here, this is now a battle between insurers. Bordone always had its own general liability insurer who continued within that. So there's no prejudice to Bordone. There's no detrimental reliance. The equitable estoppel argument must fail because we're trying to create coverage here that doesn't exist to begin with. And to just briefly address counsel's point regarding the New York limitation endorsement, which is contained in the ARCH policy, there is a scenario where that is not necessarily triggered. I do want to point out that this is now an exclusion as opposed to an additional insurance endorsement. So the burden to demonstrate that this exclusion applies and that there would be no coverage for Bordone for the underlying action at all is very high. There are multiple points that would need to be proven, including that there's no possible factual scenario where the insurer may eventually be held to indemnify the insured. And there is that scenario where the New York limitation endorsement, it requires for GSC to have maintained a general liability policy that provides coverage to Bordone as an additional insured. Well, there is an additional insured endorsement in the Nautilus policy, so it is additional insurance is maintained, but there are different factual scenarios where, as here, that additional insurance simply wouldn't be triggered.
Okay, well, thank you both very much.
Thank you, Your Honors.
The next case for argument is Sayreville Seaport Associates versus Indian Harbor.
Good afternoon, Your Honor.
Good afternoon.
Your Honors, may it please the Court, Michael Lichtenstein from Lowenstein Sandler on behalf of Plaintiff Appellant Sayreville Seaport. Your Honor, getting right to the nub, Appellant in sum argues that at worst, there are two reasonable
the areas that you're seeking to have coverage provided within the map, the 2007 Rue Associates map, and those areas were excluded. They weren't called by the names that they're called today. They didn't use the name ditch and Proxia line and open areas and Area 4 Parcel B. Those names weren't used, but those areas are the areas that were excluded on the map.
Well, Your Honor, we see two different reasonable interpretations of the exclusion. One I would call determinative, referring to the map, and one illustrative. And the court adopted the determinative view by relying on that language as shown on the map. So if you read the exclusion, it identifies excluded areas three ways. It says by a geographic identification, like C1 is the first one, by name, the Marcellus parcel, and then it says, as shown on the map. And you'll recall the map expressly says on its face that it's an approximate depiction of those areas. So as we see it, there's two ways to look at the language as shown on the map. One could be it's determinative, meaning the map is the map, and those are the areas. And it doesn't matter what, in reality, C1 actually is, and it doesn't matter in reality what the Marcellus parcel is, or in our case, the North Ditch, the Praxar line, or the other areas, which are the three areas that we're seeking coverage for. Right, so that's the interpretation that the court viewed, that the court adopted. But I think there is another reasonable interpretation that makes this particular exclusion ambiguous and should have caused the court to deny the motion to dismiss, and that is The as shown as just says there's an illustration on a map that nobody disputes is not exactly accurate. I don't know why it is, and that's really why we would need discovery in this case, because we know that the map was produced for reasons that have nothing to do with the insurance policy. There was an affidavit submitted in opposition to the motion to dismiss that explained why the map was created and that it was known to be inaccurate.
But, you know, this insurance policy, with all those endorsements that went through a good portion of the record, was not put together by two guys out on the street. I mean, obviously, there were some very sophisticated people that prepared this insurance contract, and you made reference to this lovely map that has a date. It's a little hard for me to see because I need to blow it up a little bit, but it dated November 19th, 2007. There are a lot of other maps in the record, but this is the map that you're talking about, is this map. And why would you be making reference to this map? I mean, maybe the line is maybe not exact, but it's within the area. I mean, it's not on the line, it's within that area. I mean, how else were you going to show it? And clearly, as I said, this does not look like a policy that was negotiated, you know, over a dinner and then you went home and that was it. I mean, it's a little bit more sophisticated than that.
And I really can't disagree that it would appear to be sophisticated. What I can say is that there is absolutely no evidence before the Supreme Court that discussed record evidence, that discussed how it was negotiated, who negotiated it, in particular, who drafted endorsement 15. We just don't know. And that, again, is something that would be the subject of discovery so that we really could get to the nub of the matter. I mean, there's really a serious question here, and that is, why was this particular map, inaccurate as it is, referenced in the exclusion?
I don't even see, though, why you get to that question when the document by itself says, quote, as shown on the map, close quote. It seems to me that by including those words, you agreed that the map, as imperfect as it may be, is what you're going to live by. Well, and so I don't understand what about that would give you the right to go behind it.
Well, because, Your Honor, the text of the endorsement says C1 as a geographic area. Now, C1 is a known quantity. The insurance carrier knew what C1 was, and we know what C1 is. And it defines it identifies the Marcel X parcel. Now, that parcel has a meets and bounds definition, and we know exactly what that is. There are reports referenced in the policy that tell the insured what that is, and there was record evidence before the Supreme Court that informed the court that the depiction of that area on the map is not, in fact, the meets and bounds description of the parcel itself. And that's what I think gives rise to the ambiguity. As shown as could be definitive, and that's what the court said. Doesn't matter what reality is, this is what you agreed to. But when someone says something is as shown as, that doesn't necessarily mean that that becomes the end of the discussion about what a particular parcel actually is or is not, especially...
I don't see, I'm having trouble understanding how it could mean something different from that.
Well, when the map itself says that the areas are only approximate depictions...
I know you were hanging your hat on that before Judge Cohen also, but the exclusion endorsement number 15, is that endorsement number 15 says, no, the insured and the company agrees to the following policy changes, and you list them all, and it makes reference to this map. So, I mean, this is it seems to be fairly obvious that this is the deal you made. This is the endorsement, and this is the map, and that's what you're going to use. Whether it's not exactly the way the map was or it's something's approximate, this is, you had to use something, this is what you guys chose. Now you want to say, well, you know, I don't really like how it turned out too much.
Can I quickly answer? I know I'm red.
Yes, you can.
So what I would say is that, Your Honor, because the geographic locations have an independent existence, which were known, and because the name of the parcel has an independent existence, what I don't quite understand is why everyone presumes that the phrase as shown as becomes the beginning and end of that analysis. Yes, it's an illustrative, it's a visual depiction of an actual real life piece of property in the real world. And when the map tells you we didn't do a meets and bounds, right? We didn't get that accurate, so that you can't rely on the fact that if you study it as the judge did, and I recognize, Justice Cohen looked very carefully at and couldn't find a gap, but it doesn't matter in our view because it's not sufficiently accurate that that type of review would be meaningful.
Okay, thank you. Let's hear from your adversary, and you'll get a few minutes in rebuttal.
Your Honor, initially I want to apologize for looking at my phone. It monitors my hearing aids.
It's okay.
Your Honor, there is no ambiguity. In fact, you heard several times just now, meets and bounds. The words meets and bounds aren't in the record at all. That's a brand new argument that just was made up. The map controls. In fact, the map is used in the map is used in 3 different endorsements, the same language, as shown on the map. The map determines where the excluded areas are, the locations. The name of those locations means nothing.
Well, how do you know what they're talking about if now they have names and they didn't have names? How did they describe them so you can figure out where they are?
You need a description.
Right.
So that you can identify it on the map. It could have been called the blue areas on this map, the red areas on this map, Area 51 on this map. It's immaterial. What's material is you need a reference and the map. It's a geographic exclusion. So all you need to do, and this is all that Indian Harbor did, you take the locations of the contamination that was submitted by Sayreville. You show those locations and you lay them on the map. If they're in excluded areas, there's no coverage.
And you are covering for one of the areas, right?
That is absolutely correct. There's an area that is not, that on that map, Area B, is not excluded. Radiological contamination has been found in that area and is being addressed and is being covered. Okay. The exclusion controls. The parties decided to use the exclusion. How do I know? Because it's in the policy. Which party proposed it, which party drafted it is immaterial unless the exclusion is ambiguous. It is not ambiguous. It's straightforward. It tells you exactly the locations of the contamination.
And why doesn't the approximate, the fact that the map itself describes it as approximate, create ambiguity?
Because the particular areas that are at issue here are not located on the boundaries of any non-excluded areas. The boundaries, the north ditch, for instance, is between the Marcelex and the ore storage. Both are excluded. There is no gap between those areas on this map. There are gaps between other areas on this map. And if something was in a gap area that is not excluded, well, then it would be covered. And in fact, the record shows that there were some contaminants in those, I'll call them fringe areas, that we didn't know exactly whether they were in or out. Fortunately, ultimately, no remediation was necessary in those fringe areas, so we didn't have to address that issue. But these issues, Praxair, again, Praxair and open area, those are monikers that Sayreville calls this area, but those are monikers they made up once they discovered the contamination. Has nothing to do with this policy. The fact that those words aren't on the map is absolutely immaterial. Just like
they discovered the areas, obviously, after the map was created.
That is correct. That is correct. And they came up with names for them, which are fine, but those names are immaterial to whether or not they're covered under this policy. The map controls, it's the location that controls. Briefly, I would also like to mention the Praxair claim. The court also dismissed that because the claim came in 4 years after the contamination was identified. Now, what the defendants have, what Sayreville has said is, well, we should get a chance to give our explanation for that. Well, they had a chance in their complaint, and they didn't. And then they had a chance in response to our motion when we claimed that the coverage was excluded by late notice. And they said nothing. They said, well, it's too early, we may need discovery. You don't need discovery for Sayreville to explain why it waited 4 years after getting the initial results to make a claim. Thank you.
Any questions? Okay, thank you.
Very briefly, Your Honors, I promise. So first of all, going to your question about how do you know which areas are approximate, that's exactly what I'm trying to articulate, perhaps not well.
But I didn't see anything in your papers that said that there's ambiguity as to this particular area and whether or not it's included. Is that in your paper somewhere?
I can't, as I'm standing here, I can't tell you exactly where, but it is 100% in our papers. I mean, we argued this below and we argued it on appeal that.
But is there a map that shows that?
There is, and it's in the record, Your Honor. In fact, you can even look at a map that's at record 179, which I think was actually submitted below by Indian Harbors Council. That's a map that actually shows the North Ditch, and there's no dispute in this case. The North Ditch was known to exist long before this policy was ever issued. The Praxar and open areas may have been designated later, but the North Ditch absolutely existed prior to the policy being issued. And I think, if my notes are right, that if you look at that map, it'll show you Marcellux, it'll show you ore storage, and right in the middle of it, it shows you the North Ditch. That's the actual map, right? And now going back to the ambiguity in the RU map, that's the problem, right? The approximation was it makes it look like there's no ditch between those two parcels, but there's a map that's in the record that came from the insurance company that shows you the North Ditch, and it's right in between. And there's no dispute, and I know for a fact in our papers, we identified two other reports, both that were submitted to the New Jersey Department of Environmental Protection, which clearly indicate that the department considers the North Ditch a separate area for Marcellux and ore storage, and actually has a map that shows it. So that's really, and I understand there may be a head scratcher. Why would the parties agree? And Justice Cohen made this same comment, and I empathize, but that's what discovery is for, is that I don't know, nobody here knows why the parties chose to refer to a map that was inaccurate. I just don't know. But that's why the motion to dismiss should not have been granted. And we can take discovery on that, and then we may find our answer.
Okay.
That's it, Your Honors. Thank you so much. I appreciate the time.
Thank you both very much. Next case for argument is People versus Guillory.
Good afternoon. May it please the court. My name is Elizabeth Vassley, and I represent appellant Mr. Kendall Guillory. The trial court made 3 separate errors, denying 3 of the defense's motions to strike potential jurors for cause. The judge's patience was evidently wearing thin on the record. He stated they were, quote, bleeding, hemorrhaging for potential jurors, and this reluctance to strike was apparent from the record.
But counsel, he still gave you an additional peremptory challenge, correct? Or gave defense counsel an additional peremptory challenge, and doesn't that sink your claim about these 3 jurors?
Your Honor, there was only 1 additional challenge given, but there were 3 errors with the for cause. So if 3 extra challenges were given, then Your Honor, then that would be right. But because
you used the 1 that was offered, so if you didn't even use 1, why would you have needed 3? And why aren't you precluded by the fact that you didn't use the 1 that you were given?
at this point in jury selection, it was towards the very end. They asked for an additional challenge. At the time that they were doing the majority of their jury selection, they had no idea that this additional peremptory was going to be granted. And practically, they're saving challenges. They're maybe not using them when there maybe would be a juror they would strike because they have 3 less challenges than they otherwise would have had. The jury would have been very different if they had those 3 additional challenges in the very core, the most consequential time of jury selection, in the very last panel when they're granted an additional challenge.
But aren't reversals on this issue always premised on the fact that there are no peremptory challenges left?
Your Honor, in cases where there's a single error and a single peremptory challenge, then that is where that principle that's in the statute comes into play. It doesn't make sense to read the statute, which is clearly preoccupied with a harm-type basis. Well, of course, if you have one extra peremptory on the table, then that challenge or that for-cause denial back way in the middle wouldn't have made sense, because that whole time they never used that extra challenge.
The three jurors that you're raising an issue about, they ended up off the jury, right? They were peremptory challenged.
That's correct.
So you don't have an issue with them in terms of the jury that was actually impaneled. And now when we get to review it, what we find is, well, however this jury turned out in terms of selection, you still had a peremptory challenge left. So what's the complaint?
The complaint is, Your Honor, that in the middle of the jury selection, when they're down 3 challenges, and you have 5 defense attorneys here that are all trying to agree, they're down 3 peremptory challenges, and so they're gonna make different choices. They're gonna save those, oh, I only have 1 left, I only have 2 left, I can't strike this juror when I would have really, really wanted to. And so they were deprived of 3. We're not just talking 1 error. 3 is a very big number, especially when there's 5 co-defendants.
Except that if there were somebody on the jury who you didn't want, why didn't you use that last peremptory challenge to get rid of that person and then say to the judge, this isn't fair, we should get 2 more? But you didn't do that, or not you, but your trial counsel.
Your Honor, the ship was sailed many panels before.
I don't understand that. Presumably the person who's on the jury who you're not happy with was on the jury, or otherwise you wouldn't have wanted to challenge them. But so there must have been, was there someone on the jury that you were unhappy with?
There were many people on the jury that perhaps the defense would have used a peremptory challenge on if they had 3 additional challenges, but they didn't.
But they had 1 and they didn't use it. So why doesn't, I mean, I don't understand how this is different from our decision in People versus Major from 2019, which said basically if you don't use all your peremptory challenges, you're out of luck.
If there was just one error by the court for cause, and then there was 1 extra challenge, then those errors would cancel out.
That's not what the law says. The law says that if you don't exhaust all of your peremptory challenges, you foreclose that issue. It doesn't say, well, if you made 3 motions to strike 3 jurors and each one was denied, then the fact that you're left with 1 peremptory challenges doesn't mean anything because you should have been granted those challenges anyway for cause. That's not what the law says.
I did want to address my excessive sentence point. I can see.
Can you do that on rebuttal?
Yes, Your Honor.
Thank you very much.
May it please the court, Matthew White for the people. Your Honors, the claim that the court erroneously denied 3 challenges for cause is unreviewable and meritless. As Your Honors noted, defendant had a peremptory challenge at the end of jury selection, and that makes the claim unreviewable. It doesn't matter how many challenges for cause are raised on appeal. In People v. Lynch, the Court of Appeals held that the denial of challenges for cause to 2 jurors were not reviewable, even though the defendant had 1 peremptory challenge left at the end of voir dire. And People v. Lynch and People v. Majors dispose of that claim, and accordingly, it is not reviewable. In any event, the court acted in its discretion on the merits. None of the 3 potential jurors had a state of mind, likely to preclude them from rendering an impartial verdict, and all 3 assured.
Could you address the sentence issue? Because I believe the defense position on this is that the defendant kicked Soto only once, and therefore this 7-year sentence is unwarranted.
Your Honor, this was a gang assault on a helpless and unconscious individual, Danelle Soto, who was killed as a result of the attack. It left his family devastated, and while the defendant is clearly depicted striking the victim 1 time on the video, it is quite a blow. When the other people had stopped attacking.
It was a kick in the head, right?
Right. He ran up to him and stomped him on the head. When he had a clear shot, evidently left an imprint of a shoe on his face, and the trial court noted the powerful force of the blow. There's no medical testimony about the imprint on the face other than that it existed, but if you look at the video, you can see that the defendant stomped him on the head in that same location. So the fair inference is that he struck him with such force that he left an imprint of his soul on his
You got
face.
7 years and a possibility of 25, right?
Yes, Your Honor. The sentencing range was 5 to 25 years. The defendant received 7 years, which reflected his lack of criminal record and the fact that the video only shows him striking the victim clearly once. It looks like at another point in the video he was trying to get at the victim, but there are other bodies in the way because this is a gang assault, and so it's not entirely clear that he managed to strike him a second time. But in light of the facts, there's no reason to modify his sentence in the interest of justice, and I ask that you affirm. Unless Your Honors have any questions, I rely on my brief and ask that you affirm. Thank you.
Thank you.
This case is an example of an aberration of character in the truest form. Mr. Guillory has no criminal history. This was his very first arrest and very first contact with the criminal justice system. He was a hardworking man. He worked for FedEx, Columbia University, a great father, divorced, but never ever failed to pay any child support to his children, supporting his children, and has an amazing family. His parents have been married 33 years and deeply miss their son. And the context of this really is the wrong place, wrong time. There were no weapons. This wasn't a group of people that went to a club that night to hurt someone. This is a bar fight.
I'm sorry to interrupt you. It was 2 years above the minimum, right?
2 years above the minimum, Your Honor.
And Mr. Soto died, of course. And also, in the video, it appears that Mr. Soto is not doing anything after the first punch. He's lying on the ground. I mean, all those factors, this is all in front of the judge, of course, and the judge also heard the mitigating factors that you've just recited. I mean, how can we, in the interest of justice, change that? I mean, change the sentence?
Your Honor.
Or why should we, I should say. We absolutely have the power to do so.
Mr. Guillory's co-defendant did strike the decedent to the ground and his head hit the sidewalk, but this was a fast-moving, split-second decision that Mr. Guillory deeply regrets. And he's been punished enough, 5 years, Your Honor, for someone who has no criminal record. His life's never going to be the same. He can't go back and work for FedEx. And 5 years he has is a significant time for someone that panels of this court have held in other cases, in manslaughter cases where people have died, similar facts where it's all this steady employment, this aberration of character. In Rodriguez, there was a manslaughter in first degree reduced from 6 to 8 years to 4 to 12 years. And in that case, they also cited supporting their children and not missing any child support orders. And in Kuramura, it's another manslaughter one, 8 1/3 to 25 years reduced to 5 and 15. And in that case, there was even 3 stab wounds and a knife.
Okay,
Here, there was no weapon. I'm out of time. Thank you very much, Your Honors.
Thank you. Next case for argument is REAP versus NCRNC. Go ahead, counsel, you may begin. You could take off your mask if you'd like.
May it please the court, I'm Ellen Fisher from Scholes and Miller on behalf of Health Alliance Hospital, the appellant.
Did you establish that the decedent had been turned every 2 hours?
Yes, Your Honor, the record does reflect that the patient was turned every 2 hours.
How does the record establish that?
The nurse's notes note that on every shift.
There aren't nurses' notes for every 2 hour switch in position, is there?
They do note that they were turning every 2 hours during the shift.
That's like at the end of the shift they put that in, correct?
Correct. That is how they documented that. And QT2H by the plaintiff's expert's admission does mean every 2 hours. That's the significance of that notation.
But
So did the defendant's expert create an issue of fact about that, whether or not the decedent had been moved every 2 hours?
I don't believe that the plaintiff's expert did raise an issue as to that because the interpretation of that record is inconsistent with reality, that the patient is turned every 2 hours. Q2H has only one meaning.
But don't you have, and this is in the record, there's a sheet, which is in the record at 2890, that actually reflects when the patient is turned.
There is one sheet that reflects that, yes, and there's also some.
And it's the only sheet, it is the only sheet that reflects that. There's no other sheet.
The nurse's notes do reflect the turning every 2 hours, though, and also the restraint documentation, because he had to be frequently restrained. And that those records also reflect that he had to be repositioned every 2 hours.
Are they as detailed as this sheet in 2890?
I'm sorry, sir, I didn't.
Are they as detailed in this sheet that is on the record at 2890?
They are, during the time that he is.
Is it just a notation that says, we did this, but not as detailed? Because this one actually has the time, and it says when the patient was turned and positioned, whether right or left. And it actually indicates the time when they did it, as opposed to just one general broad entry in the record.
Those records are more detailed, but the record does still reflect that every 2 hours. That's the significance of those notations. The interpretation by the plaintiff that means that the patient was only turned at the moment that there was a documentation is not consistent with the record, because that would reflect turned patient, not turned Q2H, which is what's written there. So it's not consistent with the record for him to interpret that to mean the patient's only turned twice a day in the ICU for a whole month. I know there was one.
Is that the plaintiff's expert's position, that the decedent was turned only twice a day?
I believe that there was some inconsistency there, but at one point he did state that only twice a day or twice a shift. I think that I mentioned that in the reply brief, that he does take that position. And that's, yes, I read 698.3. He said that it was only done 2 hours per day, so he was only being turned for 2 hours a day. And then I guess the other 22 hours he was being left in the ICU unturned. And at other points it was only done twice a day. That's at 6984 and 6987. And if that's the basis for his opinion,
Let me turn your attention to page 6977 of the record, where the plaintiff's expert goes through what's happening on some of those days. Isn't he on 6977 of the record saying that he was turned only twice a day? Why isn't what's stated at 6977 indicative of being turned only twice a day?
well, I'm sorry, that is on August 13th, it does say turned in position, but I don't have the actual record in front of me. This is his interpretation of the record.
It's his affidavit.
Yes. I'm pretty sure that in most places that he referenced, when you go to the actual record, it says turn to position every 2 hours.
Okay, let's hear from your adversary, and you'll have a couple minutes for rebuttal. Is that okay?
Good afternoon, Your Honors. May it please the Court, Carl Tegmeyer, Sanaki, Newman, and Turret, for the plaintiff respond of the estate of Hubert Reed.
I wondered if while we were thinking about it, if we could go to this issue about the turning and what if anything, you feel that you put into the record that raises an issue of fact as to whether, in fact, the decedent was turned every 2 hours, as the records seem to suggest, as indicated by defendants?
Yes, Your Honor. Well, the plan, the treatment plan, as Mr. Reep was at a high risk for skin breakdown, was to turn and position him every 2 hours. But in fact, it is not charted, it is not documented that that was done as it should. Every 2 hours, there was to be a note in the record indicating that this was performed.
But apart from your claim that the record doesn't show that, do you have any affirmative evidence that he was not turned every 2 hours?
Well, Your Honor, there's an axiom in the medical field, not charted, not done. So if it's not in the medical record, there's no proof that it happened. That's the very reason for medical record documentation. It's the very reason for the turning, repositioning, and hourly rounding record flow sheet in the record at page 2890. Defendant cites to the flow sheet plans where twice a day they do braiding.
So your expert says at page 6983, defendant Kingston's records consistently reveal that such steps were not followed or implemented. Most flagrantly, the requirement that turning and positioning was at most done only 2 hours per day, and as such, Nurse Bax's statement to the contrary, there must be a typo there. There must be a missing word. Nurse Baxter's statement to the contrary is not addressed to the evidence herein. So what justifies this statement? He says, Kingston's records consistently reveal that this wasn't done. What in the records consistently reveal this? I mean, it's very easy for him to say he wasn't turned, but the records, according to your colleague, do show that there was turning every 2 hours.
Your Honor.
What does he point to contradict that?
Yeah, Your Honor, in explicit detail, record page 6977 to 6980, my expert goes through each and every notation to the best of his ability in this thousands of page record to indicate any inference that there was turning and positioning. And in fact, he credits approximately 50 turning and positioning events over the course of the 23-day admission. There should be well over 250 turning and positioning events.
Can I ask you, so what you're saying, not charted, not done, so are there other things that are being charted during the 12, I think usually the nurses are on 12-hour shifts, but assuming something like that, so during the 12-hour shift, they're charting what they do when they do it, not at the end of the day saying they were, by the way, he was also turned every 2 hours. So other things were being charted?
One thing they were charting with regularity was restraint documentation, which the defendants cite on this appeal, they didn't cite below. Restraint documentation has nothing to do with turning and positioning for prevention of bed sores. Restraint documentation is literally went and checked the restraint, adjusted it, make sure the patient's safe. Nothing to do with turning and positioning.
But what I'm saying is, were there other things that were charted during the day, but this was just put at the end?
So I'm not sure I'm understanding the question. They were doing Braden scale assessments twice a day, which,
I mean, were the nurses coming in every couple hours to take their blood, check their vitals, do the stuff that?
Oh, yeah, well, there
and
is.
do they chart that when they come in?
Yeah, there's lab records, there's things to indicate. But this is something that's special. They have to, it's in every 2-hour protocol. They go and they do a more formal assessment twice a day, which is what they were charting, and they were saying we're supposed to be turning and positioning every 2 hours, but they simply don't document it every 2 hours. Just very briefly, we also have departures with the failure to properly assess on the Braden scale.
So your point about 6977 is not that they show that he wasn't turned, it's just that they don't affirmatively show that he was turned.
So starting on 6977 through 80, those are each and every notation that the expert identified in the record, identifying where they did chart it. And as I said, it's 50 times, it should be 250 times over the course of the admission. Unless there's any further questions.
Anything else that you were
Well, yeah, there was also an issue.
One other point, I'll give you 30 seconds.
Thank you, Your Honor. There's one other departure that we note, which we think is important in the record. It was this issue about failing to provide a special mattress. Again, there's inconsistent documentation. There's lack of documentation with when and what type of mattress was in place. What's clear in the record, though, is that a static mattress was requested on August 23rd. It was not provided until August 27th. During that time, the patient's bed sore exacerbated significantly.
Okay.
Thank you.
Thank you very much.
Your Honors, I just wanted to reemphasize the fact that the very same records that are used in these citations by the plaintiff's physician are the same ones that also say Q2H repeatedly.
Say what?
Q2H, which is every 2 hours.
So what is your response again to what begins at page 6977 and follows for several pages, which your colleague says shows that he wasn't turned every 2 hours?
Well, Your Honor, I did get into that in detail in the paperwork.
I thought, I mean, what I heard plaintiff's counsel seem to suggest was that was the plan was to reposition, turn and reposition every 2 hours, but did the record say it was done or this was the plan?
The records say patient repositioned, turn and position Q2H, and then on page 9 of my brief, I go through all the places where that was noted. And I think it's the plaintiff's expert was very clear that Q2H does mean every 2 hours, and these are nurses' notes. They're not, well, that's our plan and that we said 50 times. It's that we were doing it and noting it on the shifts. Also, I just wanted to...
So it didn't say that, okay.
Also, the plaintiff's expert at page 6980 points to September 3rd and then says Mr. Reap was discharged from Kingston Hospital later that day and transferred back to Northeast. What's the significance of the September 3rd date?
September 3rd, he was sent back to Northeast. And on September 4th, the next day, there was some notations about an enlarged area, not any deeper. It was still, I just wanted to mention that I'm sorry, but it's not clear from the papers that there was still no depth to the wound.
Because he goes on to say from that point forward, Mr. Reap's treatment at Kingston spiraled downward. And on September 16th, he's readmitted to Kingston Hospital.
Yes, he was at the Northeast Center at that point.
Any further questions? Okay, we'll take a further look. Thank you both very much. And the last case for argument is Commercial Tenant versus Building Services, Building Service 32BJ.
Good afternoon, Your Honors. May it please the Court. Kenneth L. Kuttner on behalf of Commercial Tenant Services, Inc. Your Honors, this appeal pertains to the court below granting defendant's motion for summary judgment and denying plaintiff's motion for summary judgment.
So, I mean, to kind of cut to the chase, I was taking a look at the agreement between your client and defendant. It was on page 240 of the record. It's a 2-page letter agreement, and you know, there seems to be a question as to whether or not that agreement, and specifically in paragraphs 2 or 5, deal with only situations where they would be renting or whether it was anticipated that in this course of all this arrangement, they would go and buy the property. So instead of becoming a tenant, they're having a tenant-landlord relationship, they now own the condo, although they still have management fees. Was this all anticipated? Can we fit this arrangement into this agreement?
Well, as a general proposition, Your Honor, I think you hit the nail right on the head. That's what the dispute is about. But as a general proposition, the agreement is written in a manner to give the client, in this case the fund, the maximum flexibility so that they could use the findings, in this case management fees, for whatever purpose that they wanted to use them for. And in this case also, because the option was part of the lease, so it is a lease-related agreement that was entered into. There's no doubt that
Let me stop you for a moment. Is what's at issue here is that the plaintiff discovers, identifies what should be reductions in what the defendant is paying, and one of those things is management fees. So they're management fees while the defendant is a tenant, and then the defendant becomes an owner, becomes a condo owner.
Right.
And they get management fee benefits in their negotiations as condo owner with the seller, with the sponsor, if you will. So now, are those, the battle is about, is it not, whether the plaintiff is entitled to a commission on those management fee reductions which the defendant negotiates with the owner going forward while defendant is no longer a tenant, but now a condo owner.
Well,
is that what this is basically about?
Well, it's for the most part, that's what it's about.
So this is my question to you.
Yes.
So when you get to paragraph 2 on page 240, I think one of the things you need to rely on is the parenthetical, including concessions and reductions in bills or other benefits resulting from a transaction related to the current lease or renegotiated lease or sublease, including assignment of a lease. That's something which you point to as showing this is very broad and we're entitled to get. But my question to you is, when you look at that, it speaks about a lease. Going forward, you're no longer dealing with a lease, you're dealing with a condo ownership.
But the negotiations, as I think I just tried to explain to Judge Kapnick, the negotiations were prior to according to the fund, that was the final step. The management fees were the last remaining obstacle. And the management fees are the same. They tried to create a distinction in the papers that management fees or a condo are different from those of the tenant. Their witnesses couldn't say what the differences are because there aren't any differences.
There's a marked decrease in what don't they start, if I'm recalling correctly, there's a request for $800,000 to something?
They reduced it from $800,000 to $400,000.
40 or 200, something like less than $200,000.
The same methodology, the same basis for reducing the management fees, the whole argument was identical to what CTS had identified. And I want to answer your question,
So you want us to hold as a matter of law that the management fees that someone would pay as a lessee are looked at the same as what someone would pay as a condo owner?
I don't think that determination has to be made because the provision, in the parenthetical provision that you just cited, specifically says that it's a transaction related to the lease. The option, according to the decision of the court below, was part of the lease, okay? So either way you look at it, and even apart from the management fees, there were what we call base year savings. That was another identification that was made by CTS. And according to the testimony of the executive director—
Did you see the lease before you entered into this contract?
I believe that the client saw the lease sometime after the contract was entered into, but they were aware that Because what happens is they're retained, and then they receive the lease, and then they receive the supporting documents. But, Your Honor, I think if you look at paragraph 2.
My last question to you, if I may, because your red light is on.
Okay.
Is there not an ambiguity here?
Well, I don't think there's an ambiguity, and I'll tell you why. Because if you look at paragraph 2, which you've done, and you look at paragraph 5 says they can't deprive us of any fee based on any agreement that the fund, SEIU, agrees, enters into with the landlord or other person or other entity, which in and of itself contemplates it doesn't necessarily.
That there could be somebody other than a landlord you weren't obligated to pay.
That's why it's written that way. So, but the court below changed its meaning.
Okay.
They nullified it.
Okay, good point to stop, I think. We'll listen to your adversary, and you'll have 2 minutes on rebuttal. Thank you, Mr. Cutner.
Good afternoon, Your Honors. Ira Sturm of the law firm Reb, Sturm and Gantrow for the respondent fund.
So doesn't your colleague make a good point in pointing to paragraph 5 when it speaks of person or entity? Doesn't that encompass the situation we have here? The entity is now this condo sponsor or seller to the defendant.
No, absolutely not necessarily so, and in fact, no. The negotiation of the contract was based upon the retention of CTS solely for the purpose of reviewing overcharges. That was the intent of the parties. In this case, the contract was drafted by CTS, and it says specifically
what reflects that that was the intent?
The intent, because
where's the evidence of that?
If you look at the right to the ability to collect a fee, the ability to collect a fee is based upon solely the ability of identifying, as defined in the contract, a refund as defined in the contract, and the payment and the funds pursuing that and obtaining a refund. None of those three things have happened. There was no identification of an overcharge because it was well known to McDade and everybody that the management fee, as negotiated in the underlying lease, was somewhat high. The circumstances were based upon a negotiation by the professional hired by the fund. That was well known. McDade, from day one, knew that that was high.
So, I mean, am I to understand that you entered into this agreement and then you didn't pay him a dime?
Excuse me?
You entered into this agreement with CTS and you didn't pay them anything?
No, the agreement was that they would get paid 25% of what was recouped as an overcharge.
And you're saying they didn't do, nothing was recouped as an overcharge over the period of time?
Nothing.
And you were billed for 400 something and it was all based on the change in the management fees?
No, in a way, yes. They claimed that the management fee was excessive. Under the terms of the lease, the management fee was well within the parameters provided for the lease. They argued that we should take the case to arbitration pursuant to the lease to convince an arbitrator that they were entitled to a lower management fee.
Proskauer didn't think that was a good idea.
Proskauer thought it was a bad idea.
So you're relying now on what in your answer to Judge Kapnick, is it that you're pointing to paragraph 3? Is that your fallback
Essentially, well, my initial argument is that it's all based upon evidence that was subject to a confidentiality order, and that was my cross appeal of the evidentiary finding.
But it sounds like what you're talking about is paragraph 3. If no refunds are achieved to or on behalf of SEIU, there are no charges to SEIU.
Correct. So in essence, there were three issues, as I mentioned. Identify a refund, an overcharge.
I suppose the point to your saying that you've recovered nothing is going to be the answer to that is probably because you've sought to recover nothing, and you turned this into a purchase of the condo, and there you achieved major management fee benefits as a result of plaintiff's efforts.
Not necessarily. The whole reason why CTS was retained was for the fiduciary obligation to make sure that the charges under the lease in the past were in accordance with the lease. There were no findings that there was any violation of a lease. There was a $500 question, but that's not the issue of this court. That was never raised. But the CTS never identified a specific overcharge.
But the thing that seems weird, and maybe I'm oversimplifying it, is they did indicate to you that the management fees that you were being charged were very, very high. And then what you did, instead of negotiating with the landlord and bringing them down and then giving them 25%, you brought them down $400 by negotiating with them in the context of buying the property, and then you said to them, well, this is the new deal we have, you didn't do anything, and you get nothing. It seems like you almost entered into this deal to get away from paying them $450,000 or something, or 25% of $400,000 or something like that.
I think the record reflects that Mr. Peter Goldberger testified that he didn't want to demand an arbitration over the alleged overcharge for two reasons. One, he didn't think he would win. He was told by Proskauer he won't win. But more importantly, he didn't want to upset the landlord in the context of the negotiations. He was caught between a rock and a hard place. If you demand the arbitration, it's going to impact your negotiations on the purchase. And contrary to CTS's arguments in their brief, they were advised of they were well aware of the purchase, and they were understanding as to what we were doing.
Well, I don't know about that. I mean, they come to us. Go ahead, have one more question.
What limits it to pass? Because I look at paragraph 1 of the agreement, and, you know, can't you interpret that, yes, it's about pass, but then you say something about that which is in present tense. So you say that this is related only to past. What nails that down for you?
It's the paragraph 1, and when you compare it to the rest of the document, it's just irreconcilable. They can't be nothing in. Well, I shouldn't say it. In the agreement itself, there are too many inconsistencies as to what the fund's obligations are. It says, per se, you don't have to pay a cent unless they identify a refund and you get it. Then later on, then there's no proviso in that agreement, and
that's paragraph 3.
Yeah, that
paragraph
says, oh, by the way, subject to the following.
But let me ask you this, counsel. This is Judge Mendez over here. To your left, to your right. Over here.
I'm sorry, Your Honor.
Okay. So they say, take it to arbitration. And you say, no, because we don't want to upset the landlord. But if you go to arbitration and you win, right, then they're entitled to 25% to their fee, 25% of whatever amount you recover.
Yeah, but...
But you don't want to upset the landlord, and instead you negotiate with the landlord, and by doing that, you say, well, you know, you're out of luck, as Justice Kapner said. Now, they identified the overcharge of the management fees. Isn't that what they did?
No, the overcharge, there was no overcharge. That management fee was allowed under the contract. They wanted us to challenge that contract through arbitration, and they were told, per se, point blank by Proskauer, they will lose that arbitration.
They wanted you to challenge that in arbitration, that it wasn't an arm's length type of management fee. But there's nothing in this agreement that requires you to go to arbitration in order to achieve a rent reduction or any sort of reduction.
Correct, Your Honor.
Okay, let's hear from Mr. Kuttner on rebuttal, and you'll have a couple minutes, Alice.
Thank you, Your Honor.
Okay?
Your Honors, regarding arbitration, Okay, first of all, Mr.
Isn't
McDade,
the arbitration a red herring because there's nothing within
it's a red herring argument for them. It's meaningless.
for both of you because there's nothing in this agreement which requires
Exactly.
them to go to arbitration in
It
order
was
to.
just a basis for them.
But what is your response to his argument, which is in paragraph 3? If no refunds are achieved to or on behalf of SEIU, there are no charges to SEIU.
Very simple. Refunds were achieved based on the definition that we went over earlier in paragraph 2, which according to the court below was a broad definitional paragraph.
Management fees going forward were reduced.
Oh, there's no question.
And for whatever reason, that may be something that has to be
Exactly,
figured
because
out.
under the holding of this court in the Northern Commercial Tenant Services versus Northern Leasing, where this court affirmed Judge, I'm sorry, I'm just forgetting which
okay.
judge's decision, but she held that it did not have to be, Judge Kornreich, I'm sorry, it did not have to be the procuring cause. So it doesn't matter whether or not the fund knew about it. And if they knew about the management fees, why are they relying on us for that? And then why, in Mr. McDade and Mr. Goldberger's emails, negotiating, none of which for 7 months we received one copy of, and that's all documented, why are they then parroting the exact language that is in CTS's audit letters from October 2014 and April 1st, 2015? I mean, this is just a ruse not to pay us. We did everything we could.
What is the amount that you say you're entitled to? Is it something like $500,000? Is that?
I'm sorry, Your Honor.
What is the amount that you say you're entitled to because of the management fee reduction? It's like $500,000?
The amount we received, according to the agreement, we're entitled to be received up through what's called the date of settlement and
Just what is the dollar amount?
The dollar amount based on the management fees alone, we have a damages analysis, would probably be well in excess of $500,000. But there's also base year charges, and we don't even know what other benefits that they received.
As a result of the sale and the new arrangement with the
because there's no question that the management fees, all the emails that we didn't receive, by the way, all say, we got them in discovery, all say that the key issue, the last issue, the final issue is management fees. And Mr. Goldberger, the executive director, said he wanted to keep the audit alive. That's our audit, okay? And also that it was the last piece of the puzzle. So unless your honors have any more questions, I'll close.
I'm going to let your adversary has 2 minutes since he cross-appealed.
I just want to say that the confidentiality agreement does not apply for the reasons set forth by Judge Engoron in the court below. Thank you, Your Honors.
Thank you. Mr. Stern, you have 2 minutes.
In the context of damages, as questioned by the court, the plaintiff is unable to prove any damages. All they have is a basis of Mr. McDade's guesstimates as to what the excessive management fee was, and no proof of any real basis for the calculation of what a, quote, reasonable management fee would have or could have been. That can only be determined through arbitration, and no arbitration was demanded, because the arbitration would have been a losing.
Let me pose the same question to you that I posed to your colleague. Is this not an ambiguous situation?
Excuse me?
Does this contract not leave us with an ambiguous situation as to just what's to happen?
I think that the contract between CTS and the fund was solely intended to address overcharges under the lease. That was what
Although
was
that's what you say, but it's not, I mean, it's got a lot of words in it which nobody can read without squinting like crazy.
But as I said before, it's ambiguous, because it's irreconcilable and it's ambiguous. If it's ambiguous, the benefit of the interpretation has to be granted to the fund, because we didn't draft it. And if there is that ambiguity, as the lower court found, The only interpretation is that, yes, it was intended to the lease.
But these aren't basically sophisticated parties who negotiated this?
No.
That wouldn't
No,
play
Mr.
any
McDade
part
is
here?
not a sophisticated party, no. It was never alleged that he was a sophisticated party. He was acting as the agent for the fund at the time. Not an employee of the fund, but an agent of the fund. I would just like to briefly address the confidentiality issue.
Yes.
I really believe that everything in the record is that they're relying on is either directly confidential or derivatively confidential. And the judge's comment about it only being raised once goes to the obligations of parties under the newly enacted rule concerning material fact statements. And if one you review the law as it's been recently amended, the only thing that you do is put facts in there. You can't put, there's no requirement or no even directive to put in legal arguments as to admissibility. It's a very confusing, regulation, and I think the judge made a mistake on that.
Okay, well, thank you both, and we'll take another look. Have a good afternoon.
Thank you, Your Honors.
Good night. Thank you.